May it please you, Justices, I appear in this matter for the appellant. I have appeared with my learned friend, Mr. Tsele, who unfortunately is taken very ill this weekend and it will not be able, this last weekend, will not be able to be with us. Also with my learned friend, Mr. Burke.
May it please you, Justices, I appear for the EFF, Mr. Malema and Dr. Ndlozi, together with my colleague, Mr. Siboto.
May it please you, Justices, I appear on behalf of the Rule of Law Project, the amicus curiae.
Yes, Mr. Gontel. I see there is an application for condemnation for the late filing of the respondent's heads. I take it it's not opposed.
I'm not opposed.
Yes, so that application is granted. As discussed, you have confined yourself to the issues that you've narrowed in your heads of argument already.
Thank you.
But before you proceed to actually begin your submissions to this court on appeal, there's something that I need to clarify with you about your papers. I see that if you look at the relief that you originally sought in the complaint, you'll find it on CB 21 in the court call. You originally sought an order, amongst others, a declaratory order that the words uttered by the respondents and their members and the supporters constitute hate speech, and also an interdict.
Yes.
And thereafter, you filed in your heads of argument a draft order which you would like this court, if it upholds the appeal, to make it an order of court. And amongst I'm not going to read all of it out, and it's before you anyway. Attached to those heads, you want an order to the effect that the words, as set out in paragraph 1, is a hate speech. And number 2, the new relief that you seek now is wider than what you first sought in paragraph 54.3, in that it does not restrict the declaration of hate speech merely to the words uttered by the respondents. It would seem to be wide enough to cover anyone singing the impugned songs. Is that right?
No, paragraph 2 is restricted to the respondents.
No, I'm talking about paragraph 1 first.
Well, the way the Constitutional Court dealt with this, particularly in Masuku, was to say that in any context the court would declare speech so used as hate speech, and then any other party who hadn't been a party to those proceedings would be free, as it were, in other circumstances to say, well, my circumstances take me out of that.
Yes, well,
so
we'll get to that, Mr. Gontel.
The declaration has to be
yes,
in relation to the words, in rem, as it were.
But what I'm trying to say, that if you look at CB 21, CB 21, the relief that you sought in the court quo,
yes,
amongst other things, is that the relief that you sought. And on that basis, the court quo dismissed your application.
yes.
Yes. Now, the relief that you are seeking now in your heads of argument,
Yes.
is it not strikingly similar to the relief, to the order that was granted by Judge Lamont?
Yes, I suppose it is. It's trying to be more specific in that sense. May I just say what you read at CD 21 in terms of paragraph 54.3 is a reference to the words uttered and used. In the draft order which we propose, we quote the words, and then in 2 we ask for an interdict against the use of those words. no real distinctions intended. We thought it clarified that were we to succeed and you think that we're wrong, that doesn't clarify the relief which is being sought, then obviously we would deal with that.
Yes. Now, the order that if I can put it this way, on appeal, Lamont's judgment came on appeal before this court.
Yes.
And they, the parties, the main protagonists, I would call it the main protagonists, agreed to a mediation agreement.
That's correct.
Now, so the order sought in this proceedings and the existing extant order of this court, can they coexist?
Well, that's one of the issues which is raised under the heading of res judicata as a defense, whether in fact a short answer to us is that there was an extinction, if you like, of the judgment, even the judgment, but of the orders of Justice Lamont by agreement made an order of court, and that if thereafter, which is what we say has happened, words are used again for reasons we can't understand and would wish to address, it suggested that estoppel or res judicata arises. It's all over.
Now, the respondents have raised res judicata.
Yes.
I understand that they would like, I see that they have raised it as the first point.
Yes.
And we would like you to deal with the res judicata point first.
Thank you. I shall do so. Thank you. Justices, sorry. What's up? Justices, it was indicated to you, or to Justice Salduka presiding in chambers, that what was referred to as a note would be put up by the respondents. Our learned friends have been kind enough to share it with us, but unfortunately not so kind as to give it to us before 17 minutes to 10.
Would you like to have a moment to
It's 14 pages of new argument, of heads of argument. So I intend to deliver our argument on the basis that the parties were required by the rules of this court to file heads of argument setting out their arguments. We know what their argument is. There was at no stage any application to you or notice to us of a need to file what is effectively substituted argument or additional argument, and we should not be put in the position of being required to repair to the passage to deal in a few minutes with it. I have been able to see that there are 2 points which are essentially main, and I shall deal with that in the best of my stride that I can, but I'm just at the beginning articulating the fact that we have...
You've just been presented with a 14-pager.
Exactly. Justices, I must deal with the res judicata point. In dealing with that, I need to set the scene, though, if you would allow me the moment, in this way, that what we now have, we're about to submit, if we get past the res judicata point, is one issue, and that is whether the Equality Court was correct in its application of what is by now an almost trite, a stabilized test, thanks to the quartet of Constitutional Court judgments relating to hate speech, the reasonable objectivity. But raised, as Justice Salduka presiding has pointed out at the outset, is the suggestion that by virtue of, as it were, the legal history in this matter, there is a defense of res judicata.
You accept, Mr. Gauntlett, that this court made an order on the 1st of November?
Oh, yes, it did. Absolutely.
Has either of the parties made any, have carried out any compliance with that order? either of the parties?
It's a question that I have asked my, as it were, others. Despite the fact that you have a record run to nearly 2,000 pages, no one on either side invoked or dealt with that mediation. You might have expected, because that is the nature of res judicata as a defense. It's normally, of course, a special plea, a special defense. You say at the outset, stop. This case is stillborn. No evidence should proceed because of what happened to Justice Lamont in a nutshell. Didn't happen. What we have on record before you is, as Justice Sarduka presiding points to, was a mediation agreement which was, as it appears, initiated or prompted or raised by the then president of this court for not the terms of the agreement, but the prospect of mediating. The parties bethought themselves, they entered into this agreement, and the agreement was then made an order of court. So what does the agreement say at Core Bundle 24? It says that the parties are litigants in an appeal to the SCA, etc., and I don't need to waste time on the detail. It says in paragraph 2, it's due to be heard on the 1st of November, almost 11 years ago. C, the parties have agreed to a full and final settlement of their dispute on the following terms. And there follow the things that they have agreed to as regards dialogue and the like. Under F, on top of page 26, the ANC, which is not a party to these proceedings, and Mr. Malema, who was then, as you know, an office bearer in that different political party from which he broke a decade ago, on the record, undertake upon the signing hereof to withdraw their appeal. Then comes G, the parties agree that this mediation agreement will be made an order of court, substituting the Equality Court order. That's the order by Justice Lamont. In this regard, the parties agree to approach, and then follow some mechanics about approaching Justice Lamont. In brief, we say this. Firstly, in the proceedings on appeal to you, res judicata was not raised, pleaded, and run as an instinctive defense as it should have been. Two, quite in contrast and in conflict with that, the parties on both sides, with too much enthusiasm perhaps, proceeded with evidence from which it is clear that mediation agreement with a different set of parties, other than Mr. Malema personally, has not borne fruition. It's quite clear vis-à-vis Mr. Malema that it just hasn't borne fruition. How or why, I don't know. It's not on record.
Mr. Gondwe, what process was made by the parties in respect of that mediation agreement?
What promises?
Process. Was the mediation order, was it appealed or challenged?
No. So it's an interesting situation, just to group on Justice Molefi's point. Parties are nudged, shall we say, by the court into think about mediation, and they enter into a mediation agreement. The mediation agreement is as recorded and made an order of court. Those parties, and it's perhaps the primary point, are not the same parties, and for res judicata, if we get past how it's to be pleaded, etc., members of the court know it has to be three things. It has to be the same parties, it has to be the same cause of proceeding, concerning the same thing, eadem causa patendi. Now, what do we have here? At every level, leaving aside what I've said as to the fact that it wasn't raised, as it were, as a special defense, the parties through their conduct showed, and I'm here, I can't, the ANC wasn't the party, but Mr. Malema was, but clearly there was no mediation. So I don't know what process, Justice Molefi, I don't know what happened, and I myself am not here casting stones at anybody in that process.
Are the main protagonists, are they not before us?
No. You say the main protagonists, that question posits that one eliminates the ANC as not being a main protagonist then. You've got to, for...
But Mr. Gorsuch,
Yeah.
Mr. Malema was named
Yes.
as a party, not as an office bearer only.
No.
He was named.
Yes.
And he signed that mediation agreement individually. And without beating about the bush,
Yes.
the main point of dispute between these two parties we have before us is Afifuelu and Mr. Malema. So he is the constant factor. I understand the ANC is not a party before us now. Mr. Malema is the leader of a new party. But it is still Mr. Malema with whom your client crosses swords to a large extent, and that is the same. And he signed that mediation agreement. And your client recognized that because in the letter that was sent prior to the institution of these proceedings, I think it is. Sorry, I'm just trying to find my core bundle. It seems to have run away.
If they've run away, your ladyship is lucky. No.
I'm sorry, that was not the... if you look at the letter that was sent prior to the institution of these proceedings, your client's... The letter is actually headed...
Sorry, may I ask where
yes,
the lady is?
it
The justice is?
CB 62.
Yes, right.
Of course, one can't hold the client to the subject line of a letter. But the point there is that it was quite clearly seen by your client that Mr. Malema acted recently in contravention of this court's previous order. And if you go to CB 64, paragraph 11 says, well, 10, your conduct and the conduct of your supporters, not just Mr. Malema, on the day is in stark contrast to the commitments made by yourself to the litigating parties, which included our client and the Supreme Court of Appeal.
Yes.
And then you say it amounts, your client says, amounts not only to a new utterance of hate speech, but also to contempt of court, in the sense that it is a blatant contravention of the order. And then your client puts Mr. Malema to terms.
Yes.
Then in paragraph 12, all our client's rights with regard to the patent contempt of a court order and your renewed commission hate speech remain reserved. So your clients clearly foresaw, although they elected not to follow that path, and that's something we can discuss. I think it might be fruitful discussion, but for the moment your clients understood that Mr. Malema, in their words, was in contempt of court, as were his followers. And so there can be no doubt that your client understood that a previous order of this court was binding. And now we are being asked, between Mr. Malema and your client, to roll back the clock and not consider that both parties undertook obligations which might be said are perfectly in line with what our Constitution aims at, promoting non-racialism and harmony between different diverse groups in South Africa, and the Equality Act too. So instead of the parties, instead of your client holding the other named protagonist to that commitment that was made in order of court, the same court is now asked to relitigate an issue which was settled on a particular basis.
I'm sorry, Justice.
I'm saying your client's I think you got the gist of,
Yes, thank
what
you.
I'm saying. And
Yes.
I would be interested in your response.
Thank you, Justice. I think at the core of the question, and Justice Keatley will correct me where I don't get it accurately, but the core, the premise of the question is this, that this letter reflects some kind of indication that the order granted by this court was considered by the attorneys then writing in November 2020 to have flouted or breached that order. Well, either as a matter of law that's right or it's wrong, Justice, but the attorney saying it so doesn't take it further. Question would be that this court had said, right, you've entered into a mediation agreement. We were taken by Justice Sarduka presiding to the mediation agreement. And the question which then arises is what we know, and that is that that mediation agreement made an order of court was not achieved for reasons which are not on record.
But were the same issue not being finalized or decided in previous litigation between the same parties?
No.
The same issue is the same.
No, the crucial thing, and this is perhaps the more fundamental point of it all, leaving aside the fact that the way the parties themselves ran it, as I say, not saying at the outset, stop, raise judicata, you can't lead evidence because of this. Number two, that the terms that the court order made before was an order by consent embodying the quintessential consensual order between people. That we agreed to do something in the form of a procedure to find peace with each other. Number three, we know as a fact from the conduct that has emerged, which is on record, that it didn't achieve it. The parties were not reconciled, as it were. When I say the parties, I want to keep emphasizing that Mr. Malema is certainly a principal actor, but we are involved in legal proceedings. He is not the only party. That one of the previous parties to the proceeding is not a party to it. But the point I want to make most fundamentally, and I haven't, is that test this. If this had been an issue of other conduct, violence between spouses or defamation, and the parties at the court door had entered into a mediation agreement and the court had said, right, I'll make this an order of court. And one of the parties said later, he did it again. That going to mediation on that issue before does not, for the purposes of res judicata, constitute the same action, the same cause of action. You can't read that mediation agreement as the one side of the case saying, you know what, if we have a mediation process that is extinctive of all my rights to stop you hitting me or defaming me or whatever the particular wrong is, statutory or otherwise, afterwards. And that is the problem here. And so in good faith, the court said, look, parties, this is a terrible social issue. It would be better if you could reconcile. They enter into that agreement.
Which was made an order of court.
Which was made an order of court. And what was it? It was a process agreement. A process agreement intended to resolve differences of the past. But for me to be wrong on this, then I have to be wrong in those analogies of what you would do seriously if there were a couple before you and there had been these allegations of violence or there had been a significant alleged defamation and there had been this mediation agreement, which, as all we know, is it didn't work, which is why we...
Cases of violence might be different, for example. These both the matter that came before the Equality Court first, and then the one that came second, and that came before this court twice, falls under the Equality Act. And we do know that the Equality Act is a very specific piece of legislation. The courts have wide powers, and the relief that can be granted extends very broadly. Why should your client and Mr. Malema not be held to that agreement in the Equality Act sphere? So we're not talking about, common law crimes, defamation, common law offences. Why should they not be held by this court to their bargain, which was obviously endorsed by this court?
As I understand it, what is posed then is that this court would say that in the circumstances posed as developed and as have been put to me, it orders the parties 11 years on. And when I say the parties, there's only one, or we should say two parties, is AfriForum and Mr. Malema. It orders them, not knowing whether there was a mediation agreement, whether and how wheels fell off, who did what.
We do know there was a mediation.
Oh, no, sorry, mediation process.
The process.
Yes, absolutely. We don't know that. So then the court would order, because this then would be the road that opens up, would be the court to say, look, we have broad powers sitting as we do in this supervisory, if you like, appellate provision over the Equality Court, etc. We order you both, the two of you, to get on with that agreement. As regards the other parties, we can't do that because you weren't. You weren't there. You never agreed to that mediation agreement. So as regards them, what? We don't hear the appeal and we give no relief. We say that it's been put to me twice that Mr. Malema is really a prime actor or principal actor. Undoubtedly. He's a leadership figure. He was a leadership figure in his former allegiance, and he is a leader of a political party, etc. Now, but they are other parties. There were other parties in the Equality Court, and they can't be disregarded. Not only that, but one of the charts doesn't involve Mr. Malema. It involved his deputy leader. So what Justice Keatley, as I understand it, is proposing as what would be the correct approach would be to say the appeal effectively fails or can't proceed, whatever the wording would be. The parties are reminded of the fact that 11 years ago they entered into this mediation agreement, which we made an order of court. We don't know why or if it failed. We order the appellant and the first respondent to go back or go to the mediation process. And we don't deal with the, as it were, what we would call the other defamation.
I was raising it more within the scope of res judicata, but I won't debate that with you. I mean, I think you've raised another path, but just, and I don't want to debate with you, Mr. Cortland, but just to point out that paragraph C on CD 25 this is the mediation agreement. And understood, I think we're all acutely aware that the ANC is not a party before us today.
Yeah.
I'll wait for you to get there.
Thank you very much, yes.
You're there? So it's 3C.
Yes.
Sort of the last third of the page. Therefore, in the interests of promoting reconciliation and to avoid intercommunity friction, and recognizing that the lyrics of certain songs are often inspired by circumstances of a particular historical period of struggle, which in certain instances may no longer be applicable. The ANC, and I'll emphasize Mr. Malema,
yes,
commit to counselling and encouraging their respective leadership and supporters to act with restraint. So, you know, if we look at Mr. Malema there, he now has different supporters, but there can be no doubt that the critiques or criticisms of hate speech in this case are about his current supporters. I'm simply pointing out that although the EFF didn't even exist at the time, as part of the mediation agreement, it was understood that Mr. Malema had supporters. And it is not that far out of the bounds to suggest that the mediation agreement didn't intend to extend into the future. And it, again, I wish to emphasize, it was based on reconciliation. In other words, it fits squarely within, it was a very mature approach that the parties took.
Well, that's the credit perhaps to the President of the Court. None of the parties may be able to claim fatherhood, but it happened. But Justice Keatley, on that, with respect what you put to me, though, has only highlighted the following problems. One is, we're concerned with conduct since. Two is, we're concerned with the fact that in these proceedings are other parties, one of which didn't even exist then. And with respect, one can't sweep it all up under the fact that it said of Mr. Malema and his supporters. That's really something which was almost a moral obligation being imposed on Mr. Malema. You could never enforce that narrowly by saying, you, Ms. Sitoli, and you, Mr. Dlamini, are, according to a book, supporters, therefore I've got an order against you. But the bottom line is, you've got post-conduct, you've got, as it were, new parties, and unless the court finds itself able to address that conundrum by sweeping those up within the ambit of an 11-year-old settlement agreement, then we say that the res judicata issue, apart from the other problems I've raised, it can't present itself.
Well, on the res judicata point, your main point is that it's not the same parties before us.
And,
Except for
the fact it's new conduct.
Yes.
New conduct, new parties.
Any other points? On
No.
the res judicata? Yeah, I think
Can I ask my last question, Mr.
Yes, thank you.
The other relief sought by Africa in the report was that the matter is referred to the Director of Public Prosecution to investigate whether the conduct of the respondent warrants the institution of criminal proceedings, among others, contempt of court. That was one of the reliefs in the court.
Yes. May I say again, because perhaps I didn't say so clearly enough earlier, Justice Molefe, the question is whether there could be contempt of court of a mediation agreement incorporated in a court order by what Mr. Malema was supposed to be or not supposed to be doing. But with great respect, the question still remains, how does that get past the problem of the different parties and different conduct? But on that, you've heard me. Thank you. Oh, sorry, Justice.
It's a matter of concern with regard to this defense, res judicata.
Yes, sir.
I'm thinking aloud, I'm looking at the words which were allegedly uttered by Dr. Ndlozi. And the question that comes to my mind is whether those words would be constituting a cause of action separate from that which arises from the utterances allegedly made by Mr. Malema. Are we dealing here with two separate causes of action between these two parties, Mr. Malema and Dr. Ndlozi? Or we are dealing with causes of action which connect in such a way that one cannot find a separation?
You find, Justice, a separation by actor, speaker, of time, and of words. It's like concurrent or separate defamations or assaults or something of that kind. One can't, with respect, as it were, contrive to weld them together and say it's one thing by actually one party. That would be our answer.
Justices, we've raised the res judicata point. We asked the court to strike the appeal with costs, because it's not an appeal that's properly before you, because you have an existing order that regulates the entirety of the dispute. Perhaps it's useful on the latter point that was raised by Justice Kambulela to go back to the Annexure A of the order that is sought by AfriForum in this court. What they are asking for, Justice Kambulela, has nothing to do with Dr. Ndlozi. It has everything to do with Mr. Malema. And it is in paragraph 1. And it is the words and translations of words, phrases, and songs set out below constitute hate speech. Shoot to kill, kiss the Boer, the farmer, shisa lama bunu, EFF, ingene ndaweni. Now that was the order before Justice Lamont. That's basically, they've repeated it here. It may be that there is one line or two that are not directly lifted from it, but the substance of it is the order that was before Justice Lamont. So that was the order that constituted the mediation terms. So, Justice Kitley, you've already taken my learned friend through the contents of the mediation agreement. It appears in core one in full. But before I go to it, it's important to note that the founding affidavit itself at CB 15, paragraph 26, makes it clear that the complaint is about the Dubula song, Kill the Boer, Kill the Farmer, also known as Dubuli Bunu, hereafter Kill the Boer. You compare that with paragraph 1 of the order that they seek. It's the same order. There's no debate about that. It's the same order. Now, what they then say in response when they are asked, well, you've got an order. And we then go to the order itself. And that is at CB 24 to CB 26. And what they did with that order, they abandoned it by agreement. It was abandoned. So it no longer exists. It's been abandoned. Instead, it's been replaced by CB 25, paragraph 3, A, B, C, D, E, F, G, and H. And those are the commitments that are made by both parties. It's in fact important to go back to these commitments because it may be easy to run through them and to overlook their significance. Justice Kitley, to your point about reconciliation and the goals underpinning the Equality Act. What the parties agreed upon is actually important. The parties agree, A, that it is crucial to mutually recognize and respect the right of all communities to celebrate and protect their cultural heritage and freedom. B, the parties recognize that certain words in certain struggle songs may be experienced as hurtful by members of minority communities. And C, therefore, in the interest of promoting reconciliation and to avoid inter-community friction, and recognizing that the lyrics of certain songs are often inspired by circumstances of a particular historical period of struggle, which in certain instances may no longer be applicable, that the ANC and Mr. Malema commit to counseling and encouraging their respective leadership and supporters to act with restraint and to avoid the experience of such hurt. D, the parties commit to deepening dialogue among leaders and supporters of their respective organizations and formations to promote understanding of their respective cultural heritages and for the purpose of contributing to the development of a future common South African heritage. E, the parties commit to continued formal dialogue amongst the leaders of the ANC and the leaders of AfriForum and DAO SA and other role players to promote understanding of their respective cultural heritages and aspirations. Those are the substantive provisions. What happens in F, G, and H are the procedural obligations. One is that the appeal would be withdrawn, and that the matter would then be referred to Justice Lamont, and the order would then be discharged, and that each party would pay its own cost. So if you look at A to E, that's precisely what Section 9 of the Constitution requires. In fact, it's what the preamble of the Constitution requires. I know that people think that the preamble is a decoration, but it actually serves a useful purpose. Because what it says, we the people of South Africa recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. But what they commit to do is most important in the first line, after we, therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and to establish a society based on democratic values, social justice, and fundamental human rights.
Mr. Mokakato, sorry to interrupt you. The mediation agreement, wouldn't you say it was also based on the purpose of Section 2 of the Equality Act?
Yes, indeed.
Which is to reconcile South Africans following the apartheid system.
Precisely, yes. I was going to say that both the Section 9 and the preamble to the Constitution are then translated into law by the Equality Act, and you see this in Section 2. So I no longer need to undertake that exercise. So,
Paragraph E of the mediation agreement, Mr. Matobi, it also commits other role players.
yes.
Besides the main protagonists who are parties to this agreement.
Yes,
So it says that they must also promote understanding. So to Mr. Bonford's point,
yes.
he says it's not the same parties before.
No, it's extra parties. So it's more parties. It's not as if it's not the same parties, but it's more parties. But it's still the same parties, then there are more. Because it's Mr. Malema is AfriForum. Those are
the
the
EFF didn't exist at the time of the mediation agreement.
Yes.
Are they a role player?
Yes, but the EFF didn't sing a song. It was sung by Mr. Malema. So that's a simple point. And in paragraph 1 of the order,
Is he the principal actor in
is
this?
the main actor, the sole actor. And that much is clear from the founding affidavit. You will see there are 7 actual instances of the song. And you will see this from CB 15 to CB 18, those 7 instances. So the first one is a rally in Newcastle. The second one is a birthday celebration. The third one is an Africa Day celebration. The fourth is a speech at the Valley University of Technology. The fifth is a manifesto of the EFF launch. Sixth is at Boer-saak Sports Ground in Zeleni. The seventh is Senegal. And in Senegal, it's where Dr. Ndoze then sings Bizani Fire Brigade, Batumlilo Lo, Bizani Fire Brigade, Shisalama Bunu, EFF in Genendawe. So those 7 instances, 6 of them are Mr. Malema, who is the sole protagonist, who is mentioned in the agreement. And the order in paragraph 1 is directed at words, not directed at the EFF. It's directed at words themselves. So it's irrelevant that the EFF was not a party in 2012 because...
The case they brought to the Equality Court was the words uttered.
Yes, it was the words and the speaker of the words. Yes. So the fact that there is the ANC and DAO, I think that's the Transvaal Agricultural Association, if I'm not mistaken. So the fact that there is DAO and the ANC doesn't detract from the fact that the principal players are AfriForum and Mr. Malema. And the fact that Mr. Ndlozi has been added also doesn't detract from the fact that the main case in substance is a case against kill the Boer, kill the farmer. And it has been sung 6 out of the 7 occasions by Mr. Malema. And Mr. Malema is a party to the mediation agreement. And AfriForum is a party to that mediation agreement. But there is more, because there is further authorities that say that one shouldn't obsess too much about the same party requirement, because what is really the philosophy behind res judicata is this desire to avoid a multiplicity of proceedings over the same issue. You cannot have the same issue being litigated over and over again. And that you will find in the judgment which has been cited in our heads of argument at paragraph 21. And the case is Royal Sechaba versus Kute, or Kut. And in paragraph 21, this is what is stated there. And there they're talking about whether to relax the same person requirement. They say, well, we don't need to relax it because it says here, the doctrine of res judicata is founded on the policy consideration that there should be finality in litigation and an avoidance of a multiplicity of litigation or conflicting judicial decisions on the same issue or issues. As Branch JA in Prinsloo said, our courts have recognized that rigid adherence to the requirement of same cause of action and same relief would defeat the purpose of res judicata. There is no reason why a similar approach should not be adopted for the same parties required. So the most important thing is that it's the same issue. These parties are still fighting about something they fought about 11 years ago. What they have done in the process is they have forgotten that they entered into a mediation agreement. And that mediation agreement was in keeping with the preamble of the Constitution, Section 9 of the Constitution, and Section 2 of the Equality Act. That's what they overlooked. Now, it is not entirely accurate that the issue wasn't raised before justice, before the High Court. It was, in fact, a defense squarely raised. I've got the heads of argument. And
sorry, can we get something cleared up on the reference counsel has just made on the Royal Sechaba case? And to the extent that counsel is zooming into res judicata and its principles, would it be correct to say that these statements made in this case elevate the defense of estoppel? So if it is so, the claim made is that the defense actually being propped up, that estoppel operates here.
Yes.
I may be having a problem with the interface between estoppel and res judicata. But how does counsel deal with it such that there is a cleanup in that area?
Because no, what we say is that the principle of res judicata applies. We don't rely for the argument I'm making now on estoppel. But what we say is that there are 3 requirements to res judicata. Same cause of action,
same parties,
same order, so. But what does that mean? Same parties, same order, same cause of action, or same issue. We say that's explained in Prinsloo versus Goldex, which is the judgment referred to in Royal Sechaba by Justice Brandt, where he says, in paragraph 23, Justice Brandt, in our common law, the requirements for res judicata are threefold: same parties, same cause of action, same relief. The recognition of what has become known as issue estoppel did not dispense with this threefold requirement. So he answers that question. And look at what he says next. But our courts have come to realize that rigid adherence to the requirements referred to in B and C, which is same cause of action and same relief, may result in defeating the whole purpose of res judicata. That purpose, so it has been stated, is to prevent the repetition of lawsuits between the same parties, the harassment of a defendant by a multiplicity of actions, and the possibility of conflicting decisions by different courts on the same issue. Estoppel, therefore, allows a court to dispense with the two requirements of same cause of action and same relief, where the same issue has been finally decided in previous litigation between the same parties. So what we say here is that you've got to keep your eyes to the fact that the protagonist is the AfriForum and Mr. Malema. The issue they are complaining about is whether or not Mr. Malema should go publicly say, kill the Boer, kill the farmer. And that's the issue that was dealt with in mediation. And that is why it's no help to say it was by agreement. Why? Because the Constitutional Court has made it clear in Ick versus Parsons that a settlement agreement made an order of court has the consequences that the issue becomes res judicata. It cannot be litigated again once the settlement agreement has been transformed into an order of court. It translates into an executable finding. So that matter is dead. This issue we're dealing with is dead because they abandoned the judgment, they accepted a settlement agreement, that settlement agreement was made an order of court. This is why, Justice Kirtley, when they began this litigation, they threatened the contempt of court because they knew that the issue that they were complaining about had been taken over by agreement and an order of court. And that's why that letter at CB 62 from Hatta Spies makes it abundantly clear that you have breached the court order. And why did they say that? It's because at CB 63, at paragraph 5C, they underline what Mr. Malema committed, which is counseling, encouragement, respective leadership, support us to act with restraint and to avoid the experience of such hurt. And then in paragraph 7 of that letter, they say your commitments were acknowledged and made an order of the Supreme Court of Appeal. And then they say, despite that, you've then gone and sung, kill the Boer, kill the farmer, in breach of that court order. So this appeal is not properly before this court. It should be struck. It's as simple as that. If there is an issue about the non-compliance with the order of this court, that should be dealt with in the appropriate way. What one cannot do is to spend 3 weeks in a political trial, because that's really what this was about. It was just a stunt by AfriForum, which ran on for 3 weeks. But in law, it was wholly improper. It should have been stopped at the beginning.
Do you have any other points on the issue?
Then we ask for costs. If you strike the appeal, we ask that you should do so with costs. Thank you, Justice Sandu.
Yes, briefly, if I may. Thank you, Justices. Justices, first, as regards the law, our learned friend referred to the Royal Sechaba case. We have also, in our heads of argument, drawn your attention to Prinsloo versus Goldex and Smith versus Porritt. Our learned friend is entirely correct, as one would expect, in saying that the old res judicata principle is not applied with the rigidity it used to be, which means that it's not a matter of catch as catch can, as it so often used to be. And what the courts do in terms of the three judgments of this court is to temper the push or desire for finality with equity, and particularly the avoidance of injustice. And I'll come back to that on the facts. Second legal point to make is that the setting here is the unusual one of what was a compromise or transactio agreeing to the mediation process, which was then made an order of this court. And in the truly magisterial leading text, which is the title in Lawsa by late Chief Justice Rabi on Estoppel, Volume 9, paragraph 634, and the authorities in footnote 3. The message in those... Sorry, para 634, footnote 3, And what the cases caution you is be careful with that which, as here, an order resting on an agreement, because the question is, in the agreement, does it appear that the parties either expressly or by necessary implication gave up the underlying rights, as it were, in perpetuity? Against that background, I turn briefly to our learned friend and the facts. And as regards the facts, the position is that, quite simply, one has the situation that there was the entering into of a mediation agreement in which there is language which members of the court with respect endeavour to make firmer than it is, and that is if, for instance, you look at CB 25, as I understood the proposition to our learned friend, that a reference to AfriForum and TAL and other role players could somehow maybe incorporate by clairvoyance future political parties or others, and in the same way whether the wording wide wording in C and D about leaders and supporters of their respective organizations. With respect, it would be this is a court order, and you would be, on this order, if you were asked to go to a particular individual and enforce it against her or against him, the question by any other court would be, really? Was that person swept up in 2020 by the terms of that order? You have a new political organization which comes to life precisely because of its differences with the old one, which was a party, and it is now somehow swept up in that. You have other named individuals like Dr. Ndlozi, who is also then swept up, it seems, and contemplated by that. We say that is not right. And if one looks at page 73 in the core bundle, you will see the express stance by Mr. Malema. The EFF and Dr. Ndlozi are not bound by the SCA order. So there is that complication. But what I want to do, just in concluding then, is to say really this, that the court is asked to do a very radical thing. It is asked then to hold that an agreement to go to mediation, which, and our learned friend accepts the proposition, that it clearly, we know, it didn't work, that what the parties must go back to mediation, that the non-parties must either go to mediation or just fall outside this process. What happens to the appeal? And may I say, lastly, our learned friend with his customary skills and agility, for which we would all admire him, switched his argument to saying that they ask for the striking of the appeal now with costs. That's not why they're here. They're here to ask for the dismissal of the appeal.
Well, if this court were not to hold the res judicata point, would you then have to deal? You would then have to deal with the merits.
Yes, I would.
Yes, and that would be dealt with the entire judgment.
I'm sorry?
With the entire judgment, the res judicata would then be dealt with.
Yes, entirely. I understood that the point about raising the res judicata point was that the court or members of it were strongly minded, prima facie, of course, that this be dispositive of the appeal, and for that reason taken us out of the ordinary sequence. But we are obviously, we must do as what the court requires. But just to conclude then, that is why they're here. And if you were minded to hold that by virtue of that 11-year-old agreement made an court order, that some of the parties, maybe the world, must go into the mediation which objectively we all accept didn't sadly work, then what we are left with is a very crucial factor in the wording of the agreement. Let me just look at CD 25. And that is that you will know at the heart of it, there's a way of interpreting it, and I refer to page 25 at line 20, subparagraph C. ANC and Mr. Malema commit to counselling and encouraging their respective leadership and supporters to act with restraint to avoid the experience of such hurt. In the circumstances of this matter, that could only mean that pending a determination, one way or the other, it could only mean that without in any way underwriting, which he couldn't do, that his supporters might go and do things he didn't want them to do, he would commit to counselling and encouraging them to act with restraint. What you have before you is the knowledge that in the decades since, the same conduct has been repeated by some different individuals, one same individual, and the issue then remains live. And so we respectfully submit that if you were to approach it in the correct way on the trilogy of cases in this court, you would say, this is not res judicata. If it were, we would have to look for the fact that it would be an injustice to, as it were, sweep it under the carpet, and we would seek it for it to be determined in that way. And if you do go against us, and you do make an order that the parties, or some of them must go back to that order, well, then we would say that as regards the costs issue, no one has been entirely successful before you. A relief has been given, mooted by the court, namely a striking of the appeal, that the appeal itself has not been determined either way, and that in the circumstances there should be no orders to costs. Thank you, Justice.
Yes, this is one other concern by me, which I'd like to raise.
Yes, Justice.
Amongst other reasons why res judicata is important is that the courts must be protected. How so? Courts can't be sitting every day to determine one and the same issue perennially until Jesus Christ comes back to South Africa. We can't do that. Now, if I look at this case, I see that Mr. Malema is the common factor, common denominator across the board. And it's not impossible to have or get another Mr. Malema rocking up tomorrow morning and singing the same song. It's not impossible. It's something that one can expect. Now, if this order, whether we call it mediation or what, but it's an order of the court, was not to be enforced to the whole world, the whole world of people who sing the same song, who are making use of it like. Why then should this order not simply be enforced against that whole world of human beings who keep repeating that which the court says that must not be done? Why should we be in and out of the courts to make the same determination? These people can be 100, they can be 1,000.
Yeah. But, Justice, we would put our answer this way, that it's really raised by the kind of debate which one had in Masuku over the gay issue, in Kwelani on the gay issue, and in Masuku on the anti-Semitism. There will always be people, sadly, who will emerge in the world and will say, burn the Jews, burn the faggots, kill the dykes, or whatever the point may be. So what the court seeks to do is to proclaim in a judgment that this for it, in this context admittedly, because everything in life has a context, but these words thus used constitute hate speech. You then can get an order interdicting other individuals or following up with criminal or other remedies against those people who, as you say, are or may in the world, as they've done in relation to anti-Semitism since 1945, denying the Holocaust and saying atrocious things about Hitler did a good thing. That's what you do. You won't stop everybody, but the courts then make a proclamation, as it were, which is that in these circumstances it's X, and that anybody else who does it.
Sorry, I don't want to interrupt you. I think I got your sense, but can I just say this case is different though from Kwelani and Masuku. There were specific words said. This is a song that it's even your client, factually, it's a matter of fact. This is a song or a chant,
Yes.
or however you wish to describe it, that has been sung and is likely to continue to be sung. It's not as if in Kwelani and Masuku it was individuals on a particular occasion saying their own words, if I could put it that way. So we're not entirely, it's very difficult in this case to separate context in which the words are expressed from the meaning that the reasonable person, perhaps I'm delving into the merits, but I think we do have to be careful that this is not quite, most of the other cases, except possibly for the flag case, which dealt with the symbol. The Dugulubunu isn't a symbol, but it has a political pedigree. And so it is far more likely to be sung. Whereas Mr. Kwelani is unlikely, or another person is unlikely to have repeated Mr. Kwelani's words. I do think we need to keep that in mind.
I think Justice Keatley, with respect, is entirely right that we would be dragged into the merits if we go too much down that way. But may I just say then in a very short response also to Justice Nshalangula, that the point we would make is that context matters, but it's been said so often, as I say, burn the Jews, kill the faggots, and that there may be unique circumstances where somebody says, I was actually busy, and that's one of the exceptions, as you know, in Section 12.2, with the historical or scholarly things, so this is why to my class I was using these words, and all that's fine. But crucially, what does need to be established is that you must know that it has been found about far simpler words in this case than those used in Kwelani, far simpler than in Masuku, that these words are capable of reasonably being understood, perhaps not in the professorial tea room that way, but reasonably understood as conveying this particular injunction, instruction, or threat. That's all. So the point, I go back to your Justice Ngulu's question, and in that regard, it should be known that this is not a question of one, as it were, irritating set of litigants who at it again. What's happened is that despite those words I read from the agreement, unfortunately, these words have continued to be used. There are others and older and voices, most recently our former President Mbeki, who said the time is gone for this. But unfortunately it continues, and so that there will be, whether you like it or not, whether it's my client or other people, if these things happen, we are simply kicking down the road a determination of what is a very, very burning issue, I'm sure, for all sides. Thank you, Justices.
We will take the tea adjourned.
Thank you. res judicata? No.
We've had both your submissions on that point, and we will deal with it in our main judgment. So you can proceed on the merits.
Thank you very much.
We've read your heads, we've read your reports, you've narrowed down the scope of your argument, and we would like you to deal with the main point.
You'd like me to be as slim as possible. I shall endeavour to be so.
Well, you have narrowed it down in your heads.
Yes. And Justice Solduka, of course, since we've had the respondents' heads of argument, the original heads of argument, so in a sense, and we've seen the amici submissions, so in a sense, we hope to be even more focused and narrow and to use oral argument, as I'm sure our learned friends will, to try to highlight the real issues of debate. And my very first submission was going to be what Justice Solduka presiding has put to me, that the ambit of true issue is very narrow. The true issue we submit is that which I mentioned earlier in passing. And that is, given that everybody, counsel for the respondents, we, and the judge, accepted, I would about to say paid lip service, but that would connote something rude, which I don't mean to, but everybody accepted that the test is the reasonable and objective test. The real fight then is, the real issue is about its application and whether, with respect, the learned judge in the Equality Court applied it correctly. Flanking what we call the true dispute are two other issues, one which you've already heard us on exhaustively and exhaustingly, the res judicata issue. The other issue which we say flanks it, and we say is not at the end the material issue, is the contention that the appeal should fail anyway because the appellant failed to prove that the words used inflicted, as they put it, severe and lingering psychological harm. And I'll deal with that very shortly, because we respectfully submit that is a horse with no legs, and not a viable argument for the reasons I shall give. But what I would like to focus on and seek to be helpful to the court is on that core issue, then, of the application of the test.
Mr. Gauntlet, before we go to the test, there's something which is bothering me, and I want to get clear from you. Your client's application in the lower court was premised on farm matters. Your client...
Sorry, premised on?
Farm matters. Your client led the evidence of Roots, who is supposedly an expert. And his testimony, his evidence is about white genocide. He is talking about the current government and the police being involved in farm matters. He's talking about the killing of whites. It's not clear to me whether he's talking about, when you talk about whites, farmers, is he talking about all whites? Is he talking about African-speaking farmers, excluding black farmers? Is he talking about Africans-speaking farmers? The reason why this question is bothering me is this, that the Equality Act does not protect farmers.
That is correct.
It does not protect advocates. It doesn't. You have to fall within a protected category.
Yes.
The case before the Equality Court, as I understand it, it was not about ethnic cleansing. It's about violence on matters allegedly committed against farmers. Now, how does your client bring itself into the protected category?
Well, my client doesn't. My client, AfriForum, is not bringing itself in, of course, and what it is doing is, and it's standing to do so, is not challenged. It is asking the question whether the words used on these occasions constituted hate speech. And then the question is how those words on the objective test are reasonably capable of being understood.
Can I stop you there? Because you are raising something which is also bothering me a lot. You see, your clients are interpreting a song sung in a language that they don't understand. They don't understand the nuances, the silences of a language. For example, I don't expect them to understand why at the funeral of a freedom fighter or somebody who was involved in a liberation struggle, I don't expect your clients to understand why people will sing these freedom songs. The point I'm saying here, you're talking about a reasonable man. And I'm thinking, if you were to take the lyrics of this song, give it to somebody in Sweden to interpret, that person is going to literally interpret the lyrics to suggest that it's call for arms. People are being incited to go and kill the farmers. The reason being that Swedish person may not know the history. He may not know about the injustice of the past. He may not know that most, if not all, freedom songs have the word "dubulibu." And context is everything. So when we talk about a reasonable man, we should be careful here. Who are we talking about? What's your comment?
My comment is that is the core of our argument that I'm taken to, perhaps a little prematurely, but let me deal with Justice Matajani's question. The question is not the application of the test, which I'm still about to try to articulate, is not one which is determined by a so-called target audience only. One of the reasons being that so-called target audiences are sometimes super sensitive or ignorant. You have to objectivize it. And you would objectivize it by talking about the reasonable, informed South African who may be listening. And that reasonable, informed South African would have to straddle language and racial groups. And on that, I must say, Justice Matajani, I, alas, lost the facility in my younger years to speak, what I once did, fluent in Ndebele. But amongst my clients, as you even see on the record, there are people who converse with counsel, isiZulu, and they do have other facilities. I'm not saying all of them, and we all know about one of the terrible hangovers of apartheid education, is that substantially white people in particular were not taught indigenous languages other than Afrikaans. But the point I make is that you, on excluding Sweden, you're excluding Norway, because you're talking about who is going to hear this. So when I say hear it, it doesn't necessarily mean standing in the street in Senekal. It means because these are public words known to be publicly reported, etc., through the media, and in the course of that to be interpreted, as would happen if somebody spoke in Afrikaans and it's put into English, then the question would be, what would this reasonably convey? And one of the short points that we really make is that you find a critical, that you take me to it, formulation in this way at the end of the very interesting report by Professor Gunner, where Professor Gunner sorry, Justices, to disappear from sight. I thought my junior was going to feed it to me. Professor Gunner, in the article that you find at page 328 of the record, that's what I'm about to ask my junior for, because I was unhelpfully sent a photocopied record, not as yours are, but imaginatively arranged in different volumes.
It's volume 2. That sounds right.
Very grateful. Thank you, Justice Molefe. Thank you. But what you will find is how she gives, much as Justice Matajani has been putting to me, a historical and political history to this song. And you find at the end she says this in that 341, to conclude, for Malema and the new party, revolutionary text and song as text go together and move beyond a playful enactment of the aesthetics of power. Song may be partly a form of play, but we can also read the Jubuli Ubuntu song and its political passage as youth and the marginalized holding the stick with which to beat the generation of politicians who they feel have betrayed them and the country. I ask you to note the words, you can also read them. Indeed. So immediately let me say, there will be some who are particularly versed in the political history, etc., who will understand and hear these words this way. There will be some who have a more projected, shall we say, view of the songs, rather as Mr. Malema explained it, that he would use it to include the current government as failing matters, and that they too would fall into this category. He does elsewhere say unequivocally that when he says Boer, he means a white person. But frankly, what Mr. Roots thinks and what Mr. Malema think are not determinative. The court has to do that, which it has to do every day in situations where it applies a reasonableness test. It has to objectivize in a context and ask the question, who would be listening to this? Forget Norway. But what we do know is that South Africans will be listening, some in the street in Senegal, and some through the media the next morning or that night on television. And how could this reasonably be understood? And that is then the point, that if, as Justice Lamont said in his judgment, you have a verb, you have an object, and you have a gesture. And you take, if I may just finish the point, Justice Matajani, you have somebody gesticulating a shooting action, identifies a group which is reasonably capable of being understood either as white people generally or as Afrikaners, and you use a simple verb, not the kind of clever language or other language that was used by Mr. Quilani, complicated language, not even the weaker language used in Masuku, but kill the Boer. I'm sorry, Justice Matajani. Thank you for allowing me to finish.
Yeah, I'm driving to this point that the Constitutional Court has said that the test for hate speech is objective, in the sense that one asks whether a reasonable person would have concluded that the person who communicated had the intention for the words to be harmful or to incite harm. Now, I'm coming back to people at the funeral. They are burying a former Mkondo member, and they are singing the struggle songs. Can it be said that their singing is intended to be harmful or to cause harm? Put differently, can there be situations where the song is sung without an intention to incite or cause harm, and there could be other situations where the song is sung with the intention to cause harm?
Well, first of all, with great respect, Justice Matajani, you've used the phrase with intention to cause harm several times, and I appreciate it in shorthand, but we would respectfully remind the court that the question is whether the person hearing reasonably could understand that is the intention, the burden of your message, the burden of your song. as the saying goes. So that's the first thing. The first thing is when you use words, we all got to be careful because words are snakes. They bite, and sometimes you may not intend it in a particular way. The point about hate speech is that what is prohibited, carved out of the Constitution, section 16.2, is hate speech as a category. Not like obscenity or blasphemy, that's protected speech. But hate speech is carved out. And then the question is, what is hate speech? And then comes the objective test.
Mr. Gordon, could I pick up on if my brother on my right has, everyone's on my right, my brother has finished his questioning. Could I pick up on something? It's a query I have for you, and I'm hoping you can assist. I don't know the answer. You pointed out that we all know it's an objective test of the reasonable person, and that's a reasonably informed South African. And you referred to Professor Gunnar and said some people may understand it one way and some may understand it another. But we've got to decide on what the reasonable person would interpret the intent to be from the words. So how then does a court where it could be interpreted one way, could be interpreted another, is it the dominant reasonable understanding, or is it sufficient that some reasonable people, unfortunately, I don't think much as the higher courts, the constitutional court has done to try to elaborate on the test, it's still very difficult in practice to apply. And it's particularly relevant in this case, where the song does have, and I'm not talking about fire brigade at this point, where the song does have a very established historical context. And where it would be difficult to say that only a small proportion of reasonable South Africans wouldn't know about that, its history and the history of political struggle and the history that's on the role that political song plays. So where you have some who might, I know it's not the subjective intent, so how do you carve a path then to the reasonable person's understanding of intent? Is that too broad?
No, with respect, we submit that Justice Keatley is wrestling with the age-old problem of a court dealing with the application of the test of reasonableness, whether it's reasonable parents or motorists or anything else. But here, in the setting, and in the setting to which Justice Matujani has drawn attention, General Smuts wrote about the British treatment of the Afrikaners as a century of wrong. But of course, you could write a book of 3 centuries of wrong, of other treatment. You have that. You have the festering, unresolved land issue. You have the kind of violence which has continued and is a reality all around us in our lives. You now have to ask, in this setting, not in Sweden or anywhere else, you use words, when I go back to what Justice Lamont put it, this verb, this gesture, and this action. And you ask how that's going to be reasonably understood by a slice of South Africa, because they are public words said in a public, outside public streets, etc., and more importantly, going to get put out there in the media. We say the answer to Justice Keatley is this. There is that phrase in Masuku, where Justice Kampepe, or it might be in Kwelani, talks about a private communication, and puts this one side, whether something is a private communication. Well, I would say it's not a communication if it's not something which is more generally put out. But the important thing is that you have Section 12, which gives a very specific specification introduced by the proviso, or the proviso in Section 12, introduced by the first phrase of Section 10, which most of us don't read. And the first words are subject to the proviso in Section 12. You can't do this. And that is for good reason. And this is where I wanted to start my argument. And if I may, I really need to make these submissions, and then I hope pick up and answer whatever other questions there are. This is the core, we submit, of the legal framework needing to be made. One, there has been a quartet of the Constitutional Court cases, starting with the SARS CCMA, where the K word was at stake, Rustenburg Platinum Mines, the Swartman case, Kwalani, the LGBTI case, Masuku, the anti-Semitism. And we start with the submission that this court would be, with respect, acutely conscious that the Constitutional Court has struggled and has sought to define, lay down as clearly as possible what the test is, and of course, as Justice Keatley says, there's still the problem of its application. But I want to combine it with something we don't refer to in our heads of argument. And that was the adjuration of Justice Chaskelson as President of the Constitutional Court in one of the first cases, Zansi versus Council of State Ciskei, 1995, Volume 4, Essay 615, and it's in paragraph 2 at 617H. And he follows the earlier judgment in... I'm sorry, too fast. Paragraph 2, and it's page 617H. I apologize, Justice Keatley, for being too fast. And he follows Justice Kentridge's, Acting Justice Kentridge's earlier judgment in Lungu. Crucial point is this. He quotes the old American Constitutional Court principle about the need for a court never to formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. And the Constitutional Court has tried to hew closely to that, has tried to define it as it can, still leaving the difficulties to which Justice Keatley draws attention. Now, what does that mean? It means in this setting that we can't just dive into Section 10. It is necessary to start, because of the way we are told to interpret statutes, etc., with this proposition. Hate speech, as a genus, is carved out of protected speech. That is Section 16.2. I said earlier, blasphemy, not. Obscenity, not. But hate speech, the framers of the Constitution said, precisely for some of the reasons articulated by Justice Matajani and Justice Keatley, we live in this raw, wounded society with unhealed wounds. And it was decided, just as it was in dealing in the Azapo case with the question of the TRC and not being able to prosecute everybody, that one of the prices to be paid is that this country would be very clear in its founding law that there is no place for hate speech. Now, of course, that has to be interpreted carefully, but it's the clearest constitutional provision I know of, which took an initial tool and cut out that category, defines to a point what it means, and then comes the act. Next point I make is this. This court was held to be wrong in Masuku and reversed by the Constitutional Court because it went off-road. It held that is effectively Section 10, it wouldn't apply, it would simply go, despite the principle of subsidiarity, it would go straight to Section 16. The Constitutional Court said, no, remember what's been cut out of the Equality Act, out of Section 10, is the hurtful provision, where Justice Navsa was reversed in the Constitutional Court. The Constitutional Court said, no, that's unconstitutional. It's a lot of things we have to take on the chin, and being hurt is one of them. So what you're left with are the two remaining sub-provisions, which then go to the question of hate in a word and harm in a word. The next large legal point I would make, and I won't develop it unless required by the court, the Constitutional Court has been at pains to say it does not mean that to succeed in a hate speech case, you have to prove harm, physical or mental. What you can't do is prove hurt. Be disturbed. The speech disturbs us all. But watch, those words are to be taken conjunctively, and there is no requirement causally of harm, there's no requirement of proof of harm. Because it would be an astonishing thing to say that somebody uses the most violent, say, racist term or anti-ethnic, religious or other term, and then says, well, you didn't show that anybody died, or you didn't put somebody in the box to say that what? This disturbed them. The answer would be, well, I wouldn't do that because it's being hurtful, it's out of the window. Crucial thing goes back to Justice Matajani's questions and Justice Keatley. What do we mean when we say that that which has been spoken reasonably conveys that there is an intention to hate? And we say two things. One is that you will not be impressed by whether it's the evidence of Mr. Roots or the evidence of Mr. Malema as to what he may have meant. But if you were, you would find it very interesting to find, as I referred a moment ago, where's that reference, to Mr. Malema's evidence, where he says, and I think it's page 1640.
Is that the aspect you referred to?
Yes, I did. I think that's, yes, that is. And there are other similar passages. And one wants to say, as this court said in Hotz, where the suggestion was in evidence by a UCT student who'd used the word S-K-I-L-L on a T-shirt with a very small s, that it didn't intend the thrust of the word in the word kill. And Justice Wallace had said, well, it doesn't really matter, but actually it's a tall order to expect the court to believe that, when the thrust of it is what it is. And our case, and Justice Matajani, this is really my ultimate answer to you, and I'm sorry for being long-winded and getting there. Very difficult.
I promise you, I want to ask you just a question on this topic, and I want to take it. If I sing to my grandchildren,
yes,
and a neighbor hears me singing this toy, am I inciting to? No. Am I committing hate speech?
No.
So do we agree that there are instances where people could sing these freedom songs without really committing hate speech? In which case, if you say yes, in your draft, you are basically asking for the banning of the song, irrespective of whether it is sung privately or basically it corresponds to hate speech now. It's no longer hate crime.
Well, what we would say is that if you look at the interdict we seek, it says specifically from any public use. And if your concern was that those words should be mirrored, and perhaps by oversight they're not, in paragraph 1 of public, then that is the thrust of it. We accept circumstances. Firstly, those which are carved out by section 12, obviously, where Professor Gunnar or somebody else talking to her class or a musicologist is describing the history of freedom songs and says, these are the words, etc., which they are. Any reasonably informed, objective listener would say, first of all, they got the exemption under section 12, but would understand, how could I reasonably infer from these circumstances that these words have any kind of injunctive power? But if you, because I know Justice Keatley differs very profoundly philosophically from me on this, but if you say it in a public context, broadcasting and otherwise, and you know there's a segment of the population out there who are identified, whether they're Jews, or whites or Afrikaners or whatever it may be, then in those circumstances, you have a different case.
So in paragraph 1 of your draft order,
Yes.
are you referring to these words, will constitute hate speech on a public platform?
Yes. Publicly.
But the test, Mr. Goldberg, is still a reasonable, objective, and informed person.
Yes.
Informed.
Yes.
So whether it's in the public or not, if the person is, we use the objective test. Reasonable, objective,
Yes.
and informed.
Yes. No, we said so ourselves some moments ago, Justice Molefi. So may I just say, because I think the point you really...
It's the public singing of the song, that's where I don't get it. Are all the public listeners reasonable and informed?
Because as your colleagues have put to me, everything is in a context. And that's what makes such a difference. You know, if I sing, which would be an atrocity in the shower, but if I sing, then anybody passing may hear particular words, and I may be trying to get the words right for this case or something. An informed, reasonable listener is going to know these are the circumstances, that is the context.
The difficulty there, I'm coming in now because it's at that point I want to, but you want to ban the words.
Mm-hmm. In a public,
paragraph
no, Justice
I'm
Keatley.
not, sorry, let me disclose up front. I'm not concerned with the public-private.
Mhm.
I understand the
Yes,
public-private.
yes.
But in prayer 1, you want to ban the words in public.
Yes.
You are only seeking to interdict the respondents in this case.
Yes.
However, the ban against the word stands. And so, effectively, that can have very serious consequences. Say, for example, a group gather at a public cemetery to honour a fallen comrade who's 97 years old, and or whatever, and he's being buried, and they sing the song because that's the song they sang, and they wish him well, and they wanted him to hamba kahle.
Yes.
Now, actually, that is covered under 1. And somebody, another family at the same funeral, because it's public, could in fact say they're guilty, civilly guilty, but could refer it to the DPP. So there is a, you know, what I'm struggling with is the banning of the words per se, and then what you say is the context. I don't think that we can approach this test without understanding the words in their context. I would have great difficulty in accepting, let me not put it as strongly as that, to say one could simply decontextualize words on a page and say anyone who utters these or sings these, it is hate speech. You have to look at the context, let alone the private and the public. You have to look at the context. And then that leads me on to the next level of my, I don't know if it's a question or a statement. I really am trying to grapple with this. I hope you understand that. But the question, the next one is, because you refer to what Mr. Malema had said in his evidence about his own history and so on. So, is it hate speech when these respondents sing it? Because people would perceive or understand that they come from a radical political organization. So, do you understand where I'm going? I find there to be a disjunct between your approach saying the words, it's an in-rem order. I don't see how it can be an in-rem order. One must look at context.
Yes.
Koelani tells us, and Masuku, you
Yes.
must look at context, you must look at speaker, you
Yes.
must look at audience. So then are we back to, no, it's only when Mr. Malema leads the song.
Yeah.
And then we back to, let us not say those words again,
Yes.
raised in the context.
Well, I was hoping you wouldn't take me back there, because I thought you got bored enough with us earlier, having to hear us on that topic. But
No,
I
don't go there.
Justice Keatley, on the crucial question of how wide to go. What you have before you is a complaint, or two complaints related, which went into the Equality Court about particular conduct on particular occasions. And if it had been that those occasions were such as you described, which was a funeral of a colleague, comrade, going in those circumstances. Last week, Basil February, the last survivor of the Wangi campaign, died. If it was sung at his funeral, then the point would be, well, why is it in the complaint? That's not in the complaint. The complaint was about these occasions, and so your judgment, Justice Keatley, will have to be, on these occasions, did that constitute hate speech? A separate question, as Justice Sarduka was probing, is the issue of what relief to give consequentially. And if your concern is that the declarator might be confused as being too widely stated, that would mean every person instructing his or her child or at a funeral is being hit by a too in rem order, then the answer lies in every case. You trim the relief. But the crucial thing, Justice Keatley, is this. You are confronted in this court with what was sung on these occasions. And on these occasions, publicized as it was it reasonably capable of being understood as an injunction to hate or to cause harm?
Shouldn't it be understood in the context, like my sister has said, of culture and struggle? You keep on referring to Professor Gerner's evidence, and she said the song still carries huge weight as a historical statement and an inspiration to later generations.
Absolutely. Absolutely.
Wonderful.
Sorry, may I just first deal with Justice Molefe, with your leave, Justice? Absolutely. But with respect, Justice Molefe's question leaves out of account our use of our emphasis before on what Professor Gunnar rightly is accepting. Well, to put it around, turn it around and say it this way. If there is a particular meaning which is pure and historical, or pure and held by in a particular direction, that does not determine it. As it does not determine it if AfriForum has too high-raised sensitivities, and it understands it in a particular way. This is the dilemma which Justice Keatley and others have been probing, of who is hearing this and how is it capable of reasonably being understood. What Justice Molefe is putting to me is that there is a meaning and a history which interprets it that way. More recently, people like Professor Mbeki have said, President Mbeki have said, that was the past. And what also, Justice Molefe, is important is the time context and saying something now and how it is capable of being understood now. The crucial thing is, though, that you're either with us or against us. That what the Constitutional Court says is you don't go down a silo vision. That Professor Gunnar says it's capable of being understood that way. Oh, yes. But what she's leaving out of account is the test, and she's not a lawyer, so it's understood. Is this reasonably capable of being understood in another way? And I go back to the issues being raised by Justice Matajani. In the volatility and the rawness of this history, you must know that there are people alive who understand, reasonably understand it as an injunction to hatred and maybe to harm. I'm sorry, Justice Matajani. Justice Matajani, I think, was... Yeah, sorry.
On appeal, what you are seeking in paragraph 1 of the draft order is a blanket ban on anyone who sings a song, and wherever they might be. You are now saying that it should be amended to read on a public platform, but it could be a ban to anyone or any organization who's not sitting before us. So you are in effect seeking a blanket ban.
No, that has been dealt with in the Constitutional Court judgments, that you can only deal, if somebody says burn the Jews, and the declaration is made that you can't say burn the Jews.
No,
If I may finish, then what somebody else may come to court and say, but I'm saying it in this other context, I'm not hit by the order. But the court can't, with respect, shrink from that primary duty of saying that here it is, and that's the weakness in paragraph 1, and I'm busy formulating something as I speak.
I was going to say, you would accept then that it would be on the occasion.
Yes, exactly.
As it was, I think as it was said in the Lamont judgment first, and then
Yes.
it was limited, and then the broad ban. Yeah.
And in fact, I started to write the words on the occasion, so we will come up with a narrower. But
So yes, it's on the occasions that Mr. Malema.
exactly, and Dr. Ndlozi, yes,
Mr. Gordon,
Justice.
you have alluded correctly so to the fact that the problem underlying this case, insofar as the application and the test is concerned, is the how part of it. How you do it.
Yes.
It's difficult.
Very, yes.
But we are guided. We've got, for an example, the case of Masuku,
Yes.
where we are told that in approaching a matter of this nature, and starting, of course, with an acknowledgement that we are on appeal here, we are
Yes.
guided by the record.
Yes.
So no amount of leaving the record, going elsewhere is going to assist us. I think we should be focused. Now, with these words, kill the Boer,
Yeah.
one has to interpret that using the canons of construction. What's the meaning of who? What was the meaning of kill, kiss? And then start from there. And for sure, the parties are not together on that one. Even the court never would not be in a position of saying that for sure we know what the meaning of Boer is. Because Boer could be a farmer, Boer could be something else that I've seen in papers. In other words, the interpretation is the tool that we must not abandon. Now, coming to the test, it is the court that must drive the process, the reasonable man test. It is the court itself which must make up its mind and say, a reasonable person in a position of a listener, what would he say? But that listener must be informed about the circumstances under which the utterances were made.
Yes.
Now, in this case, if I recall, the court of court has had analyzed the evidence.
Yes.
And it excluded certain pieces of evidence.
Well, it excluded the entirety of our case, yes.
For reasons that are stated in the judgment. Okay. Now, thinking about how to disagree with the court of court would be a difficult task for me. Because if it is true that the exclusion was warranted, then we would be having the version, that is the circumstances, in dealing with the aspect of context in which these words were uttered. Then we will have to deal with what the respondent, has had to say in evidence in affidavit of the case will be together with his witnesses, Professor Ghana, and so on. Now, given that the banning is just out of the way, we can't begin the debate on the basis that there's going to be a banning of anything. We have to answer the question whether the words amount to hate speech within the prison of Section 10 of the Equality Act. So in determining that, you don't boer-saak, you have to have regard to the materials in front of you, the materials or the evidence and everything that the court of law had in front of it, and then make the determination. Now, I thought that if that is the approach, that is interpreting the words based on context and purpose, how can we have a result different from that which the court of law gave you?
Thank you, Justice. First of all, with great respect, the approach is not interpreting, correct approach is not interpreting by reference, as Justice Ngela put it to me, context and purpose. We're not busy with a statute or a contract. We're busy with the test which has been distilled by the quartet of constitutional court judgments. And that is that which arises more by analogy in the field, as the court has said, of defamation. You look at the words used and you ask, in that context, how are they reasonably capable of being understood? Our second submission on that is that when it's put to me, well, effectively, the Equality Court ejected the entirety, as it did, of the appellant's evidence. Isn't this court then left with the fact that, as it were, as I understand it, that evidence is gone and there's the other evidence? Well, in this court, we're challenging as to how, with great respect, the court below it could have done what it did, and we analyze this in our heads of argument, which is first to expel, as it were, that evidence, and then turn to the statute and what it required. So this court is at large to decide what to do about evidence. Our fourth point is that, of course, and the cases already indicate that there's this unfortunate tendency of the parties in all these cases to start leading, as it were, too much evidence. I mean, if you take, for example, the problem in Kwelani, where there was evidence about the treatment of gay people before Mr. Kwelani said or did anything. One, it may be that the court finds it helpful to know that a lot of gay people have been killed, beaten, and the like, but that's actually not the inquiry. The inquiry is whether the words Mr. Kwelani used were such as to constitute hate speech, because we go back to the fact that proof of harm and any causal link to the harm, which was a bit of a chimera pursued on my side of the case at inordinate length in the trial, it's not a requirement. But we would be happy to approach this case on one of two bases. One is that we write that really it's what is reasonably capable of being understood, and frankly, most of that evidence doesn't pertain to this. The other is that you look at it all, but certainly not be bound by what His Lordship did below. But if you look at it all and ask the question, right, there's a terrific amount of evidence, we must ask the question, how much of this really goes to context in the sense that it's been raised, and how much, and how do we understand the answer, apply the test of whether it's reasonably capable of being considered to be hate speech, and not being necessarily a call to inflict harm. In this case, we say, you have such simple words which are capable, reasonably capable, of an informed populace, knowing, as has been put to me, that part of the history of this country has been struggle songs, and even knowing that these are words in the struggle songs. But in the events at Senegal, when the body of Brendan Horner was hanging on a fence, and to sing in the street the struggle song, as it was put in that context, people would say, reasonable people could say, that something may be rooted in history, as many anti-Semitic songs are and slogans are, going back to the history of Russia and elsewhere. But say that now, and you say it in this context, in our tinderbox, it constitutes stepping over a line, objectively speaking. That really is the core of our case, that we readily concede, accept that there is a historical and an important tradition, etc. We readily concede that there may be circumstances in which it can't be hate speech if you're a reasonable, sensible, informed person, if you hear somebody at a graveside singing that. But circumstances, the language which is used, the place where it's used, that can go to it. That's all that we're here for. And Justice Sarduka and Justice Keatley and others have been right to identify the fact that we can't take the declaration we want too far. We can't speak for all time and in all places. We can speak about what happened here. And we respectfully submit that stand on your head. This is a worse case than skill-wise. There's not even a missing S.
So you say you look at the facts and surrounding circumstances. You don't just generally ban the song. You look at the specific facts,
Yes.
specific surrounding circumstances.
Yes. And that is why you would, with respect, be bound to look at the circumstances and the facts here. We're not in Professor Gunner's seminar room. We know where this happened, and you would ask whether reasonable South Africans, with a history on both sides, might understand that there is an injunction to hate them.
How would one apply that test in the case of the former president seeing his signature on the Shinwa?
Yes. Well, I thought about this a little bit and thought, as one starts to do, how does one stop pursuing analogies and circumstances? And I would have thought these immediate answers. Number one, it's not the injunctive form of kill the ethnic group. There is this which was to the reasonably, or is to the reasonably understood person, the reasonably informed person, would be understood as being a nostalgic harking back to military campaigns and the like. That is the way I would answer it. I'm glad I'm not the judge.
Bring my machine gun and his dancing movies to go and shoot them up.
Yeah. Well, you see, others will disagree with me, amongst my clients too. And they will say this highlights the fact that you don't dance on this grave. It's not a matter of semantics. You use terms which in their language import suggest violence. And you go back to section 16, and 16.2 says, just understand, hate speech isn't protected. You go to section 10, and you're left with the issues of harm and hatred. If there's a very jovial, jubilant, and may I say musically, I don't mean any unfair comparison to Mr. Malema, but very talented singer in the form of the president doing it in certain circumstances, people will say, this is where he's doing it. What's your issue? But this highlights the fact, two facts. One is that it's right from the level of relief to be careful. But two is, and it's the first point, is that in the circumstances in which something happens, you there make the inquiry, and you either say, oh, come on, President Zuma is not doing that. It's clearly a reunion of this, that, or the other. Or others will say it falls the other side of the line. But I would be very careful, with great respect, Justices, in seeking to depart from what we have here. We have very clear instances of blunt terms which are being publicly decried and abandoned by other important leaders. And whether these and these circumstances are reasonably understood as indicating that, or do we take Professor Gunner as articulating the views of reasonable objectivity when what she says is on one meaning? That's our argument in a nutshell. I think I've made it long enough.
Thank you. You'll have an opportunity of replying.
Thank you. Oh, I was reminded there was a question about issue of what a Boer is. Well, we said in our heads of argument that all the dictionaries and history books tell you, the Oxford English Dictionary, organized on historical principles, the South African edition, has 8 pages, which I have lurking somewhere here. And the point about it is that in this country, Boer is capable of being understood by many of us in our youth as a pejorative reference to traffic policemen. But it's also reasonably capable and is understood as a historical reference, either, and I'm not given to quoting Mr. Malema, as meaning simply white people, or it means Afrikaners. Of course, the idea that it means somebody planting millies or on a tractor would not be a reasonable interpretation in these circumstances, and it's quite clear from the context that that is not what's at issue.
The point I wanted to make about it on reading the record and the evidence of Mr. Roots.
Yes.
It would appear that the case was based on the attack on farmers. He didn't say specifically Afrikaner as a group, as an ethnic, as a minority ethnic group needs protection. You also speak about the rampant violence on farms where white farmers are being used.
I think you'd find the answer, Justice Matajani, in our opponents' heads, in paragraphs 33 and 34, where they say, in paragraph 34, when quizzed on what the Boer means, Mr. Roots responded, it is the Afrikaans word for farmer, but it is also a word referring to a particular ethnic group. This case was, with respect, not brought on some bespoke basis that, as it was put, a particular profession is entitled to and should have protection in that way. What the evidence went to was the plight of people who, and farmers in this country, certainly white farmers, overwhelmingly Afrikaans, but that they live under circumstances which were described at great length in the evidence. My own approach is...
Being kind to your client's evidence-led. It's very difficult, if one reads your client's complaint and the evidence-led, to understand why this was a hate speech case. Mr. Roots, quite frankly, went through paragraph after paragraph of his book, which strangely is called In the Terms of the Hate Speech, that is now before this court. And quite frankly, reading his evidence, it reads like a complaint by someone and his own personal views on double discrimination, how the government is doing nothing to protect farmers. It is really difficult, unless it was an attempt to make out a new case to get away possibly from res judicata. But I have no, it is quite difficult to fathom what your client's case was before the court of court, why those days of evidence had to be read, and why such a platform. I'm afraid it really makes this, this ongoing litigation between the parties look like two parties with differing political ideologies, and they're hitting their heads up against each other. You can understand why the court is asking the questions. It's asking about res judicata.
Yeah. May I just say on that one thing would be very clear to this court, that our approach, rightly or wrongly on appeal, is a very different one. And as you know, it doesn't free me from the consequences, whatever, but as regard our approach, what we didn't understand, maybe say on both sides, and with respect of the judge, was not pulling the parties up and saying, wait, This is what it's about. The judge was of exemplary patience, perhaps too much so, apart from those who had cell phones in his court. But otherwise, was of exemplary patience in dealing with the situation. But it does not change the complaints lodged in the Equality Court. The evidence, frankly, I have to say a lot of it was off the map. Some would say off the wall.
Thank you.
Thank you.
You have an opportunity of replying.
Thank you very much.
You've heard the debate.
Thank you, Justice Salduga. What I propose doing, I have prepared notes that are circulated. I'm not going to go through them, but I will try and respond to the points that have been made, the salient points. I want to make two first points around interpretation of Section 10. They have now become important to make in the light of Mr. Gauntlet's submissions. I'm going to speak your constitution, if you don't mind. Yeah. So in the light of what Mr. Gauntlet has submitted, the first one is that Section 10 of the Equality Act is one of the provisions that give effect to Section 9(2) of the Constitution. And that point is made in Kolane. And the second point, which is also made in Kolane, is that Section 10 of the Equality Act is informed and shaped by Section 16 of the Constitution, which is the freedom of expression provision. Something that should be corrected in Mr. Gauntlet's submission is that this is not hate speech under Section 16(2) of the Constitution. In other words, this is not unprotected speech. What we are dealing with is protected speech. In other words, it's speech that falls under Section 16(1). And that you will see clearly explained in the Kolane judgment at paragraph 76 and 77. And even the complaint that was before the Equality Court was not a complaint of a violation of Section 16(2). It was a complaint of a violation of Section 10(1) of the Equality Act. In other words, it's a complaint that absent Section 10(1) of the Equality Act, the speech otherwise would have been entirely protected. It would have been under Section 16(1). So we are not dealing with unprotected speech. That distinction is important. Its genesis is the Islamic Unity Convention case, which is referred to at paragraph 44 of the Kolane case. So if we are then dealing with protected speech under Section 16(1), and we are dealing with an act whose intention is to limit and regulate that speech under Section 36 of the Constitution, then we have to be very careful about the extent to which we are going to ban people from speaking, because that's really what is at issue here. And two quotations are useful to add. The one is in paragraph 3 of our note, which is the extent to which we stop people from speaking or singing or chanting is set out in paragraph 26 of the Islamic Unity Judgment. And this is what it says there. It says freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference. And then the part we've highlighted, but also to those that offend, shock, or disturb the state or any other sector of the population. So if you are offended, you are shocked, and you are disturbed, you must live with it, because that's the price we pay for freedom of expression. And the second point, which is important, is the type of equality we are engaged with, which is in paragraph 58 of Kolane again, that it's the type of equality that aims to tackle systemic patterns where the structures, context, and impact underpinning the discrimination matters. So what we know in South Africa is that, according to the Bester judgment,
You said Kolane,
paragraph 58, yes, 58. So what we know from the Bester judgment, which is at paragraph 52 of the Bester judgment, is that racism has not disappeared overnight. So it persists. And what we know from SARS versus CCMA, and it's a judgment of Justice Mogoeng, is that it's not any type of racism that we are concerned with in South Africa. It's racism against blacks. In other words, it's white racism that is unique about South Africa. And it continues to persist despite the provisions of the Constitution. So you see that at paragraphs 3 to 14 of the SARS judgment. And so that's why we can now make 2 points that the jurisprudence recognizes: Kolane, Islamic Unity, and SARS judgment, and the Vesta judgment. The first is that there is a persistence of racial discrimination against blacks, and that racism is embedded in the social and economic structures. And the second is that there is a duty, both publicly and privately, to end the systematic and racialized marginalization of blacks in the economy.
Mr. Madam, you will be reading from this notes that Mr. Conrad has already objected to.
Yes.
And of course, we have not distributed it to us. Is it just an argument that you presented
Yes,
to us?
this is an argument I presented.
Yes. May I just, sorry to interrupt you, Royal friend, but make it clear that there was no application to hand it up. I would have objected. There is no reason for any of us to come to this court with new heads on the morning before,
Yes, you've told us that.
which were not even conveyed to us and which we don't know, and yet it's now accepted by the court. We will ask not.
No, that's what
Thank you.
I've asked him about it.
Yes, thank you. I've noted the objection. I've not. The only point I'm making is that I could literally read from that, or I could be helpful to the court by giving a script of what I am going to argue. Let me continue where I stopped. The second point is that there is a public and a private duty to end the systemic and racialized marginalization of blacks in the economy. And this point is made by no less than the Chief Justice in paragraph 10 of the SARS case. And what he makes clear is that the duty to end racism should not be framed in apologetic terms, and that it is proper to call out racism. And that is why he is worried about the patronizing caution. Those are his words, the patronizing caution. That when blacks speak out against racism, and they do so in words that are unapologetic, they should not be patronized and told about rationality and speaking softly. So,
Could I just interrupt you there? And this again is clarification. Could you look at section 4.2 of the Equality Act? I'll read it for you if that's easier. And I just wondered if you could comment on
Justice Kittley, let me open this section. It might be more helpful for the discussion.
So it's under the guiding principles.
Section 4.2, yes.
Yeah. And it says, in the application of this act, the following should be recognized and taken into account. A, the existence of systemic discrimination and inequalities, particularly in respect of race. I'm leaving out some inequalities generally recognized in all spheres of life as a result of past and present unfair discrimination brought about by colonialism, the apartheid system, and patriarchy. I raise it here simply to ask, it's a guiding principle. I don't know whether it applies more in a unfair discrimination case under the Act, or how are we, does it have any relevance to determining whether, how we interpret the understanding by the reasonable person of the intention of the words of Dukulubu?
Yes, no, Justice Kittley, it is directly applicable. We know this from Kolane, because it's from Kolane that it is expressly stated that the Equality Act, and Kolane is about Section 10.
Yes, no, I understand.
Yeah, that the Equality Act is informed by two constitutional provisions. It's Section 9, which is the equality provision, and it is Section 16, the freedom of speech provision. And it's in Kwelane where it is also recognized that there is ongoing systemic discrimination against blacks, and in fact it's also stated there that also against members of the LGBTIQ+ community. So this guiding principle applies with equal force to Section 10 as well.
See, the difficulty with this case is, which is why I'm grappling with this, is that most of the other cases have dealt with accepted, previously discriminated against groups, including the flag case. This is the one case where there's a flip. And so this Section 4.2 might it's not a case where we're dealing with an alleged form of hate speech against a previously discriminated against grouping.
Yes.
And I don't think I'm expressing myself terribly
No,
well, but it's very difficult because everyone's equal under the law.
Yes.
One must accept that simply because you were previously the white person who was previously in the ascendancy or had power under apartheid. You can't not be protected by hate speech.
Oh, yes,
So
I see the
that's
point.
what I'm trying to grab.
I see the point. No, I see the point. I think what I'm making here at the very beginning of my address are two arguments. The first argument is that despite the so-called constitutional revolution of 1994,
Yes.
one of the distinctive benchmarks of apartheid, which is racism, it continues to persist. And that racism is also embedded in the social and economic structures of society. So whites have more and blacks have less. And that's a consequence of 350 years of colonial dispossession. It's not me speaking, it's Justice Mogoeng. So when one is engaged with what the actual economic power is, the actual economic power lies in the hands of whites. And this is, in fact, the constant theme throughout the trial in this case. The second point I'm making is that Justice Mogoeng says this racism, it is permissible to call it out. And when it is called out, it must be called out in unapologetic terms. And that judges should not allow themselves to be used to put what he calls patronizing cautions. So that's the first point I am trying to outline. I am not suggesting that whites do not deserve protections of...
I wasn't suggesting,
Yeah.
you were suggesting.
Yes.
I was just trying to explain
Yes.
what I was investigating.
No, precisely. And so where this debate ultimately ends is that the nature of the political speech that is intended to destabilize the economic consensus that still leaves whites at the top can be shocking, it can be disturbing, it can be offensive, but it's perfectly lawful. And so we say that it's compatible with the Constitution to destabilize the status quo that continues to marginalize blacks by using language that shocks, that disturbs, and that offends. So that's the baseline from which the arguments move, and this is the triad of cases: Islamic Unity, Kwelane, and Masuku. Those are the cases that have dealt with hate speech. Islamic Unity, hate speech under Section 16.2, or unprotected speech. And Kwelane and Masuku, protected speech, but hate speech under Section 10.1 of the Equality Act. So how then should we apply this now that we've looked at the governing principles? We've addressed this at in our note at paragraph 10, that the framing of the section right now says, subject to Section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. As Masuku holds, that section can be divided into two. The first part is that the speech must be based on a prohibited ground. And there is a list of prohibited grounds in the Act. And once it is not based on a prohibited ground, there is no further inquiry. And the second component is that the speech or the words, when construed, must be reasonably be construed to demonstrate a clear intention to be harmful, incite harm, and to promote or propagate hatred. But what's important is that both of them are underpinned by objectiveness. So when you are answering the question, is it based on a prohibited ground, you must do so objectively. And that is what we find in Masuku at paragraph 144, where it is said, and context to the objective person is important, not just important, but instructive of meaning. And then again, in Masuku at paragraph 154, it is stated here, words cannot always be taken for their plain meaning. And then finally in Masuku, it is not the mere inferences or assumptions that are made by the targeted group that matter. So we know three things. Words must be read in context, words should not be taken literally, and the assumptions of the target group are irrelevant. And that is why we criticize the judgment of Justice Lamont, because he expressly stated that the search is not to discover an exclusive meaning, but to find the meaning the target group would reasonably attribute to the words. He got the test so fundamentally off the mark because he focused on what the target group thinks, let alone the complication of who this target group is. And not only did he say, I want to know what the target group thinks, he also said, if the words can be interpreted differently by what he called different portions of society, then each portion of society must be given its own meaning. Now that is plainly not the law, and that is why he was doubly wrong. He was wrong by saying the purpose is to find the meaning of the target group, and he was wrong in saying that if there are different interpretations, we must look at each portion of society. He seems to have been taking the country backwards and not forward. What is important is obviously the judges must decide for themselves what the words mean in context and whether or not in context the words are based on a prohibited ground or not. So when we then deal with that first question, were these words, we know the words we are dealing with. The complaint is about Julius Malema, and the complaint is he has chanted, kill the Boer, kill the farmer. And he has chanted, Tobule Boni. What the judge decided, and you'll see this in paragraph 95 of his judgment, he asked an objective question. Would a reasonable person interpret the words as being based on a prohibited ground? He ultimately decided that no, a reasonable person would not interpret the words to be based on a prohibited ground. It's reasonable, well-informed, as Justice Molefe pointed out. The first thing he did in paragraph 104 is to situate the chant in a larger repertoire of struggle songs against apartheid. So I'm not an ignorant person. I live in South Africa and I've been in this country. Even if I'm young, I know at least something about the history of this country. That's the approach the judge adopted. And then he says in paragraph 104, he says, before democracy, this song or this chant was directed at the apartheid regime, and more particularly to the dispossession of land of the majority of the members of society by the colonial powers. And then he says, since the dawn of democracy, the song is directed, according to him, according to Mr. Malema, still at the issue of land justice. And in this respect, more towards highlighting the failures of the current government. He insisted that the lyrics of the impugned song, similar to other freedom songs, should not be interpreted literally, but within the context of the struggle and the political message that is sought to be agitated. This could have been drawn directly from Kwelane or from Masuku. Lyrics must be interpreted contextually, historically. Lyrics cannot be interpreted literally. Lyrics must be interpreted in the context of the ongoing struggle for freedom, because it's actually not true that, according to Mr. Malema, there has been freedom. And then he says, I found no reason to reject his evidence. He accepts his evidence, and that's the approach he takes towards the interpretation. And Mr. Malema's evidence was also consistent with Professor Ghana, who stated that the song cannot be interpreted literally as agitating an attack, but as a tool to advance the interests of land justice. And he repeats.
Could I ask you something, unless you know, to ask when the issue comes up?
Yes, I'm happy to answer now.
Thank you. Justice Monahlehi has been criticised for applying a subjective test. Yes. Because he accepted, it's averred or submitted what Professor Gunnar, how she understood what the words to mean, what the words meant or would be here. And then Mr. Malema, who gave evidence about what the song is pointed at, what the purpose of singing the song is. And that, it's been said, is a subjective approach, which of course we know is not the test. Yes. My question is, as I understand the law and the interpretation of the words in their context, and as I understand Masuku, we could certainly look at Professor, and I don't understand Mr. Baldry to suggest anything different. The evidence would nonetheless be relevant to the question of context. Yes. Historical context, the role of political song, the role of gestures, and so on and so forth. That's factual, it would not go to a subjective interpretation, as I understand it. Yes,
no, that is true. It's not fair to say that Justice Molahlehi applied a subjective test. He, in fact...
I said that's what the criticism...
Yes, absolutely, it's in the heads, yes. It's not a fair criticism. In paragraph 95 of the judgment, he expressly, I think it's volume 11, judgment is volume... just find the judgment. Yes. Thank you. Yes, so in paragraph 95 of the judgment, which is at 1943 to 1944, volume 11, he expressly states the inquiry to be conducted in applying the objective test is what meaning a reasonable reader or reasonable listener of ordinary intelligence would attribute to the statement in its context. And then he cites Khumalo and the other judgments. What he then did when he applied this, he said the interpretation that a reasonable reader or a reasonable listener of the words, who is informed, not an ignorant listener, someone who is informed, would have two constructs that are consistent with Mr. Malema's. One is a historical construct, which, by the way, Justice Kitley, was common cause, because what had happened is that when Mr. Roots was called to give evidence, he said that he heard about the song for the first time after 1990. He knew nothing about the song historically, so which meant that on the side of AfriForum, there was just no evidence about the history. It was only Professor Ghana. So, paragraph 104, he makes it clear, before democracy, this was the purpose of the song. Post-democracy, he says, I accept what Mr. Malema says, that the song still continues to play a similar role in highlighting land injustice. That's not him saying, I am deferring to Mr. Malema. That is him saying, in context, Mr. Malema is correct. That is what we do all the time when we construe the meaning of words. We say, witness A says X, witness B says Y. Either I come with a third interpretation, or I adopt one of the interpretations that the parties are advancing. That is not to adopt a subjective interpretation. It is still to apply an objective interpretation. In other words, Mr. Malema's interpretation is consistent with the objectivity that the statute requires. There's nothing wrong with that. And he is also right in applying Professor Garner's construct, which is, it is an ignorant thing to take political speech literally. Political speech has to be understood in the context, in time, and in the light of its purpose. South Africans are very smart people. They know that when Mr. Malema is chanting in a stadium, he's not in a killing field. He's at a stadium. So, what is clear then is that the words as construed by the court objectively are not a referral to a race or to any ethnicity. They are a referral to a system of racial dispossession and oppression. Both racial dispossession and oppression were the hallmarks of apartheid. We are told by the Chief Justice to call this out explicitly without apology. And so what Mr. Malema is doing is to call for the destruction of a system of apartheid and its present-day incarnations. And for as long as, and these are his words, for as long as white supremacy exists, and he said white supremacy exists, and interestingly, Justice Kitley, there was in fact no counter to that in the trial. And for as long as white supremacy exists, which is manifested in land and property injustice, Mr. Malema is entitled to call for its destruction. He's entitled to call for the destruction of the evil system of apartheid. And so we say that he is bound to call for this eradication. And he made it clear that when he uses farmer or Boer, he doesn't do so in ethnic or racial terms. He is doing so figuratively to shine a spotlight on land injustice which Africans continue to experience. And we've referred to all of the lines. There were many, many lines in the cross-examination where they tried to sort of trap him with this idea that a farmer and a Boer, etc., but he always made it clear that these are figurative expressions, and I'm doing so to shine a spotlight on land injustice. He didn't spare the current government either.
So, Mr. Ntobi, you are saying that he must be allowed to say these words in public and in private?
Both publicly and privately, because in public, that is where most of us will interpret for ourselves as reasonable people. And in public, as reasonable people, we will understand that Mr. Malema's expression of those words is expression about the system that continues to marginalize Africans.
So if you look at the paragraph 1 of the appellant's order,
Yes, I have it. Yes, paragraph 1, I mean, this is the ban that is wide and unlimited. And Mr. Malema...
It's different from what was sought in the Equality Court.
Yes, it is different from what was sought in the Equality Court. But it's clear that that is what is being sought here.
Is a blanket ban?
It's a blanket ban. This one says, the words...
Or is it a ban with a wider, with a wide ambit?
Yes, Mr. Malema is being told that nowhere in the world can he ever say this, no matter the context.
Mr. Malema, isn't it paragraph 1?
Well, it's not Mr. Malema alone, it's everyone. Yes, I mean, there is in fact...
but he's been interdicted in paragraph 2.
Yes, but the fact is that in paragraph 1, by way of a declaration, he is stopped. And there is no one else, in fact, who will not be stopped by paragraph 1. And that's one of the problems, technical problems with the way the order is framed. Justice Kitley raised the important point about freedom songs and people at a funeral recalling a fallen soldier and still singing Amba Kahle Mkhonto and still singing Sizimisele Ukwabulala Amabhulu. And whether in those contexts, it would be appropriate to still issue the ban. The fact of the matter is that there are no contexts in this case that would be excluded by paragraph 1. But even if we look at what they sought in the Equality Court, they are not entitled to it because Mr. Malema, in the 7 contexts that they cited. They cited 7 contexts. The 2016 rally, the 2017 birthday celebration, the 2018 Africa Day celebration, the VUT address, the manifesto launch, the sports grounds launch, and the Senegal. 6 of them are actually celebratory events. Celebratory events, where it's the EFF marking a particular point in its history. It's a celebration. There is only one that is actually a tense affair. It's the Senegal affair. So one cannot even grant, and I'm going to address the court shortly on the Senegal affair. So one cannot grant the orders in CB 21 either, because it's the words uttered, and we were told, limited to these particular events. So 6 of the events are celebrations. And then one of them is what was happening at Senegal. And the Senegal instance is a curious one, because what had happened on the evidence in Senegal is that there was a court appearance, and there were what Mr. Malema called white supremacists, right-wingers, who attended there. And they threatened the police, they threatened to disrupt the court process, and they threatened to beat up other people, basically black people. So Mr. Malema says in his evidence, I have seen this, and I've seen this white supremacy in action. I've seen white people that are terrorizing African people in action. And then he says, this was then a response, and you'll see this evidence, this was then a response at the time. So you'll see this at volume 9, at page 1567, volume 9. And it's important to look at that specific context. So it's important to look at that context of Senegal. That's the only one that is actually emotionally charged context. The others are just the EFF celebrating with its supporters. So when you look at that Senegal context,
Do you say
1567, yes, at volume 9. So we start at the very end of 1567, where he is cross-examined to explain why he thought it was appropriate for the EFF to chant. I think it was Dr. Ndlozi, actually, in that case, who was singing. So the last lines there he says, you see, in Senegal, my brother, it is a community, those people you see there, it is a community protesting against white supremacists. They are agitated, they are angry at what the white supremacists have done in that court, where they broke into a police station and they chased the police away. They also broke into the court. They fired guns right on the face of 2 females who were there managing the door at the court. And the people respond in the manner they did to show their displeasure at what happened. They never killed anybody. They were singing to show that they were angry. Do not take away the right of our people to show the white supremacists that they no longer have a place in South Africa. So for me to condemn them will be to promote white supremacists, and I'm not going to do that. So that's the only instance that's truly emotionally charged. But once the context is explained, it becomes wholly improper to then say, in the face of white supremacy that is displaying itself through violent action by white people, a song, nevertheless should be banned. So that's the context that he explained. And we have no other evidence from AfriForum about the Senegal context. That's what was going on. We have no evidence of what Malema's evidence. Yes. And in fact, my Leonard Jr., who ran the trial, says that there was in fact video evidence of this gun being shot inside a courtroom. And then a police van was also burnt to ashes by these white people.
I think we're moving on to a new point, Mr. Kotobi, because I want to take a comfort break from my colleagues.
Yes, perhaps it might be the right time, because maybe I should make one point, and that will be in 30 seconds, and then we might take the adjournment. So what we say in relation to the first point is that there is no basis to say that the words are based on a prohibited ground. And far from being based on race or ethnicity, the words are based on political ideology. What Mr. Malema was doing was to employ a figure of speech in a dramatic, adversarial, and inflammatory way. And he was doing so to draw attention to a political problem and to his brand of politics. And when all is said and done, Mr. Malema's political rhetoric is pure political speech. It's not racialized or ethnicized speech. And for that reason, these words, understood in context through the prism of a reasonable, well-informed South Africans, are not based on race or ethnicity. They are based purely on politics. So that should be the end of the inquiry. I am now going to address the second part of the test, if I'm wrong on the first one, which is the clear intent to cause harm or propagate hatred. But I'm happy to take an adjournment. Thank you. I also thought the same.
I'm glad you did.
Yes.
Making your next submission.
Yes, thank you, thank you, Justice Nduka. So I have already dealt with why we submit that the chant is not directed at a racial or ethnic group. I want to deal with, if you reject my submission on that point and you say it is, it could only mean it's directed at, I suppose, white Afrikaners. But even that is not the case, because not every white Afrikaner is a farmer. So there's still a lot of work to be done to get to the point that this is ethnic or racial speech. But if you are against me on that and you are able to formulate a target category, the next question is, can these words reasonably be construed to demonstrate a clear intent to cause harm or propagate hatred? The judgment in issue is Kwelane that tells us at paragraph 176 how this analysis has to be undertaken. And it identifies three questions that must be asked. Firstly is, who is the speaker? The second is, what is the context of the speech and its impact? And the third is, what is the likelihood of inflicting harm or propagating hatred? You have to ask those three questions before you come to the conclusion that the second facet of section 10.1 is met. So if we then go to the speaker, we know there are two speakers, but there's one speaker really, it's Mr. Malema, and then there is a secondary speaker, which is Dr. Ndlozi. But what we know about Mr. Malema is that his organization stands for land justice, and it seeks to bring forth to society the questions of the incomplete struggle for freedom. But what happened at the trial is interesting, because what AfriForum sought to do was to portray Mr. Malema in the same category as Mr. Bikindi of Rwanda, who was calling for the genocide of the Tutsis. And that was the main cross-examination against Mr. Malema and against Professor Ghana on the standing of the speaker. Now, we see this most clearly in volume 10 of the record, and at page 1792 to page 1795. We see there Mr. Oppenheimer, who has resurfaced under the guise of an amicus in the appeal, but he really was always partisan. We see him there pressing the expert on the comparison between Mr. Malema and Mr. Bikindi. Professor Ghana ultimately answers the question at 1792, where it should be line number 18, where she says, I do respect the judgment of this particular court, but I think that what is very important to take into account is context. Now, if I may say that about Mr. Bikindi, you obviously know an awful lot about him, far more than me, I am sure. And then he explains why this is different. He says, but he was also a member of the Interahamwe. And there was Interahamwe within Rwanda. It was this group that was vehemently anti-Tutsi. The government was anti-Tutsi. The secret is, it's possible that there were a number of radio stations that were being published. So they funded. There was a huge push, you could say, that the whole government, if you like, there was this Interahamwe movement that Bikindi was related to. So to simply say as a general proposition that a song can incite has to then be qualified by the context. So, and that is the line that the professor took. So the comparison with Mr. Bikindi was correctly rejected by the judge because, as the expert explained, it is not as if you have a movement that is running the government, that has control over the means of propaganda, and that is clearly hacking down every white farmer they come across. What we have is a group of youth celebrating the establishment of an organization that speaks to their concerns. So nothing really is to be said about Mr. Malema's position, He does not have the same or similar power that Mr. Bikindi had. He is not King Dingaan in 1897 calling for the killing of the witches. His killing is truly metaphorical. So, on the first question about the standing of the speaker, there's nothing there to see. And then you have the second question, which is, what is the context of this speech? What's the context of the speech? What was it trying to do in the speech, and what were the external circumstances of the speech? Again, we have to go back to the record, and I appreciate Mr. Gauntlet's careful calibration, if not distancing from the record, but we have to adjudge the case based on the record. The main context that AfriForum pursued was the context of farm matters. That's the case they brought. And what they tried to raise were two propositions. Proposition number one was that Mr. Malema is causally related to the farm matters. There is a causation between kill the Boer, kill the farmer, and the farm attacks. If there is no causation, they try to suggest there's at least a correlation, this idea that there are a lot of farm matters, and if you repeatedly make this statement, you make it acceptable or normal. But what we know on the evidence is that Mr. Malema made it clear that he is concerned about crime in general, and that there is no reason to single out farm matters, because crime in South Africa does not discriminate on racial grounds. But what we also know is that the testimonies of the witnesses that were called by AfriForum could not establish either a causation or a correlation or any linkage between the statement and the farm matters. And in the note, I've gone through all of the portions in the record where this is absolutely clear that there was no causation. It's from Ms. Muller's testimony at volume 7, page 1236 to 1237. Mr. Prinsloo's testimony at volume 7, page 1252. Mr. Human's testimony, you remember who Mr. Human was. He is the person who counsels victims of crime. He himself said that from the accounts that he got, no one could relate them to the actual chance by Mr. Malema. Mr. Roots, the supposed experts, could also not substantiate the claim of the linkage between the farm attacks and the chance. In fact, he mentioned one instance where someone applied for amnesty and said that the reason they did the attack was because they had the song, "Kill the Boer, Kill the Farmer." But none of them could point to Mr. Malema. But we also know the context of the TRC hearings, that in order to get amnesty, you had to link your attack to a political objective. And then the authoritative statement from the government showed actually that more than 89% of these attacks actually were motivated by robbery. Even the victim accounts that were called at the trial showed that robbery primarily was the motive. There is not a single person who said there was any linkage between Mr. Malema's celebratory song or celebratory utterances and the farm matters. So these are the contexts immediately brought to court by AfriForum. They were rightly rejected by the Judge Akuo. And then there are other contexts. I have already referred to the court to the 7 instances that have been raised, 6 of whom are the EFF celebrating either at a rally or at a birthday, and one of whom is the Seneca instance. So none of those are in the context of killing, which is the point about literalism and the point about what reasonable persons would think the songs mean in the context in which they were sung. So we say that the main problem which faced AfriForum at the trial as to context is that they tried to draw a correlation, if not causation, between the chant and the murders against white farmers. They could not do so, and the judge correctly noted that in the absence of that linkage, there could be no case based on context. Now, in Xolani, this is very much distinguishable, and the court is referred to paragraph 80 of Xolani. The judges there concluded, 180, yes, of Xolani. There, the Constitutional Court concluded that there was a strong correlation between the prevalence and tolerance of hate speech in a society and the prevalence of hate crimes perpetrated against vulnerable groups. So those are the facts in Xolani, and that is why the evidence of victims was important, because it drew the correlation between speaking evil against gays and lesbians and then doing evil against them. In this case, it was a stretch and rightly rejected. So on the first two questions that we must ask on the second aspect, which is the identity of the speaker and the context of the speech, AfriForum was rightly lost the case. And then there is the last part, which is what is the likelihood of causing harm? There are two problems that face AfriForum here. The first problem is that if the words are understood as political speech, as a brand of populism, because that's really what they are, it's populist speech, then there is simply no likelihood of causing harm at all, because the words have got nothing to do with encouraging or inciting a criminal act of incitement to kill. They are just political speech by a grandstanding politician, or political speech by a politician that wants to draw attention to what they stand for. And no one in their right mind believes that there is an actual calling for the killing of whites or actual calling for the killing of farmers. AfriForum also showed that they were aware that this was political speech. And I want to refer the court specifically to volume 8, basically the whole of volume 8, which is the cross-examination of Mr. Malema. It spans into 35 pages. 35 pages. And what Mr. Malema is being asked about is his ideology on land, his ideology on the economy, his ideology on racial reconciliation, and his ideology on racial discrimination. So what AfriForum had done, it had in fact played its card to amply demonstrate that the case it brought against Mr. Malema was no more than a political stunt. So we say that they simply failed to lead evidence to show why the speech is likely to cause harm or propagate hatred. Of course, there is a few people alleging to be offended by the speech, but that does not translate to harm or propagation of hatred in the same sense as the Xolani judgment. And particularly where the claimant has selected the harm. The claimant selected the harm, that the harm and the hatred is farm matters. And once that linkage between the speech and the farm matters could not be established, what that meant was that the case simply had no foundation and was rightly dismissed. So that is why we say, as the court did a quo, you should similarly dismiss the appeal with an order as to costs. Now, there is a Section 12 complaint that sort of features on the outskirts of this debate. It has not been pursued in oral argument, and I will not spend any more time with this court on the Section 12 issue, which has not been pursued by AfriForum in oral argument. So those will be our submissions, and we would ask for the appeal to be dismissed with costs.
Thank you. Yes.
Just one clarification question. Mr. Mukatoli, the Bizani Fire Brigade, how do we deal with, there was very little said on the record at all about that.
Yes.
Or in the complaint.
Yes.
We don't know that it's a long-standing struggle song. We really know not much attention was paid to it in the case. The complaint did seem to link the singing of the song to arson, which AfriForum drew back on. But how do we look as a court at the fire brigade aspect of the hate speech. Separate occasion, separate song.
Yes.
Does it form, you know, do
Well,
you
I
look
mean-
at it as one part of a bigger whole?
Yes.
Or,
Yeah.
I'm not sure, no one's really addressed
Yes.
that point.
Yes, what we see from the proposed order is that it's really treated as one and the same as the Dubula song, because from the draft order, it's not given a specific attention. It comes towards the end, Shisa Lama Bunu.
Yeah.
And
They've
then,
taken those words which would seem
yes,
to be the parallel
to Dubula, yes. And once Dubula is not hate speech on the grounds that we are saying, Shisa simply cannot be hate speech. But the way it has been run, it has been run as an adjunct of Dubula. And what we know, the context of this song is vastly different to what Mr. Malema was doing. On the sixth occasion, Mr. Malema was celebrating. On this particular occasion, there were real white supremacists that were burning the building, burning the cars. And so, if it is to be taken into account as a self-standing complaint, its context is totally destructive of any claims that it was on its own hate speech. Because one must remember, it's the context of the words at the time they were used, and it's the context of the words as we understand them historically and contemporarily. So it's not abstract context, it's what is happening on the ground. So, and that's why we say, if one looks at what they are asking for, the 6 plus the 7, those contexts are not hate speech. There may be other contexts which we don't know about, but these particular contexts they've chosen, those are not hate speech contexts. So we would say two things about the Dr. Ndlozi. One is it's an adjunct of Dubula, and whatever happens to Dubula happens to that song as well. But it has a particular sort of inflammatory context that completely destroys the arguments by AfriForum. Justice Alduga, I did not realize that the note was not in fact handed up to the court, the note that I prepared.
Your heads of argument.
Yes, the note I was using.
That's what I told you. You're reading out from your heads, and I took it that Mr. Bonnet had objected to that. So that was the reason why you actually didn't hand it up.
Yes, I thought it was handed up,
No.
but then there was an objection. Yes.
No, it was not handed up.
Yes, all right. Thank you. Let me make the offer again, in case I did not make it clear. The offer stands to circulate the note on the basis that it may be helpful to the court, because, well, I've spoken to him, he says no, but it's up to the court whether they will benefit from the
Do you have
note.
any problems if we look at the note?
I do. I will answer if I may on that.
Well, you will let us know if the court would like to get the note, despite the objection, but I will not hand it up.
But,
Yes.
but you have read out from that tape, and it has been very useful, and we thank you for your...
Thank you, Justice Aduka.
I will hear Mr. Oppenheimer before we hear you, Mr. Bonnet.
Thank you.
Yeah. Mr. Oppenheimer, thank you for your heads. You're in a different role now, so you're here to assist the board. You're an amicus now.
Yes.
Yes.
Justices, our courts have a very proud tradition of ensuring equality before the law, of ensuring that everyone is subject to the law regardless of their status. That if you are a former president or an Olympic athlete, the law will be used equally. And the Rule of Law Project's concern is that the Court of Quo's judgment doesn't do that. That the rules that are applied to Mr. Malema differ in many ways from the rules that were applied in other hate speech cases. There are really 4 issues to address. The first is that the Court of Quo seems to create a special category of protection for speech uttered by political role players. And this elevates politicians over ordinary citizens. It says that their speech is more valuable, more protected, and that is not something that we find in our law. We actually find the reverse. In Kulani, as has been discussed, the status of the speaker matters enormously. That the Constitutional Court found that because Mr. Kulani had a public role, he was a writer, that must be held against him. Secondly, equality before the law requires that the rules of evidence are applied equally in all of these hate speech cases. Now, my learned friend, Mr. Ngatobi, referenced the Kulani High Court case, and our evidence was led in that case, and all of the evidence was allowed. It provided the valuable context about homophobia and violence against the gay community, and that was pivotal in determining that Mr. Kulani's speech constituted hate speech, as much as it was stressed that there was no causal link between the article that he wrote and any of the harm suffered by the community. It's never been a requirement in our law that there has to be a causal link, and Kulani in the Constitutional Court establishes this. And of course, one of the difficulties with the Court of Quo's judgment is to exclude all of the evidence on the grounds that it couldn't prove a causal link between the song and the harm that was suffered, but it was never a requirement. Third, the Court of Quo held that the appellant failed to show that the song Kill the Boer targeted people on any of the listed grounds like race or ethnicity. Now, it seems astonishing to think that no one knows what Boer means, that when the Anglo-Boer War is taught, no one thinks it's between the British and farmers. They know that it refers to the Afrikaners, that Mr. Roots testifies that the term Boer has a dual meaning, one that it can refer to farmers and the others that it can refer to Afrikaners. And Afrikaners must be given the same respect as all other citizens in this country. That the Constitutional Court, when dealing with the term Zionist in the Masuku case, could say, well, it's clear that the term refers to Jews, that you don't have to say Jew, it can be implied by using the term Zionist. And so when there's a double standard of saying, well, Afrikaners are a group unworthy of protection, like gay people and Jews, that's a very dangerous precedent to set. And fourth, the Court of Quo's judgment undermines the founding value of non-racialism. It creates different rules for different races, and this is a topic that has come up in some discussion today, the idea that maybe some people should have different statuses depending on the color of their skin. That flies in the face of the foundational value of non-racialism entrenched in Section 1 of our Constitution. In Section 9, the idea that we're all equal before the law, and specifically in the Kamalo judgment, where Justice Sutherland addresses that issue head-on and goes into some detail why we don't have different rules for different races. I'm now going to start with the speech by politicians and why it's so dangerous. Mr. Ngatobi wants to belittle the role of Mr. Malema to say, well, he's just sort of speaking at birthday parties. This is the leader of the third biggest political party in the country, who can amass a group of members of parliament to storm the stage that the president stands on, who can have a birthday rally that is televised around the world with 90,000 people at it. This is someone who has way more stature than anyone else in any of the hate speech cases. This is someone who has a much bigger reach than someone like John Kulani or Mogani Masuku. That status matters. And it is warned about by the United Nations Committee on the Elimination of Racial Discrimination. They produced a report about South Africa where they said there is a concern about the rise of hate crimes and hate speech in South Africa, including physical attacks against certain ethnic groups and non-citizens, discriminatory statements by state officials and politicians, and the increase in the use of the media and the internet to propagate racist hate speech. And the committee further recommends that the state ensure all incidents of hate crimes and hate speech are investigated and prosecuted, and the perpetrators are punished regardless of their official status. Instead of saying that they're given a special extra freedom to propagate hatred, the idea is they must be held to account. And this is echoed by the Constitutional Court in the matter of economic freedom fighters versus the Minister of Justice, where Mr. Malema had been charged with breaching the Rights Assemblies Act for calling on people to take land. And the Chief Justice there said, "No constitutional right is absolute or ranks higher than all others in this country. In our enjoyment of these rights, a greater sense of responsibility is demanded, particularly of those who are thought leaders, whose utterances could be acted upon without much reflection by reason of the esteem in which they are held and the influence they command. After all, leaders from all walks of life ought to bear heavier responsibilities than all others to help preserve our Ubuntu, justice, and equality-based heritage and actualize our shared aspirations. So in the case where Mr. Malema is specifically mentioned as someone who carries enormous political power, the Chief Justice says you must add additional burdens to these people. Now, some of Mr. Malema's testimony gives some credence to this. He says that he believes he will be the president of South Africa. He describes the EFF as a very radical, very militant party. He says, I never said I'm somewhat moderate, I'm very radical and very militant, and I make no apology about that. And when asked whether he would embrace violence as a process to decolonize South Africa, he responded, colonization is violent. It is like racism, and the only way to deal with violence, you must be violent. Therefore, there's nothing wrong in engaging in a revolution, and one to be suggesting that you cannot be engaged in violence. Revolution itself is violence. When he was asked whether he would be happy to endorse the use of violence for his revolutionary aims, he responded, my Lord, when the time comes and the conditions on the ground necessitate that arms must be taken, we will do so without hesitation. He says, I am not scared of killing. A revolutionary is a walking, killing machine, not scared of death. If that need arises, I will kill. I will do so with no hesitancy, especially in defense of my people. We are very angry and ready to kill. Now, the suggestion by my learned friend that this is all metaphor, that this is about the destruction of the apartheid system, is complete and utter nonsense. Mr. Malema testified that he is happy to endorse killing. When asked, will you pledge never to call for the killing of white people, not a system, for the killing of white people, he refused. It is very clear from the speech itself, kill the Boer, kill the farmer, from the testimony of Mr. Malema himself, it is targeted at people on the basis of their race. And he has no problem with killing. He says it very openly. Well, the point is to say that there must not be a double standard, that you must take into account the status of the speaker, that you must take into account the testimony. So the amicus cares about the rule of law being applied equally, that there cannot be a special protection for someone on the basis of them being.
I would think, rather than highlighting aspects of Mr. Malema's evidence which are not before us as hate speech. It's the song being sung on particular occasions that are being used as hate speech, not what Mr. Malema said elsewhere.
Well, the point of it is that you must ensure that people are held to account in terms of the law. The law makes it clear that the status of the speaker matters.
I understand that. Stick to
Yes.
that line, I would think.
Now, with regards to the expert evidence that was dismissed, my learned friends for the EFF state in their heads of argument that the structure of the original trial mirrors the structure of the Kolani trial. Now, one of the bases for Mr. Rutter's evidence being disqualified was on the basis that he is a member of AfriForum. However, in the Equality Court trial of Mr. Kolani, the court admitted the evidence of Mr. Gregiaru, who worked for the Human Rights Commission, its own employee. Now, another reason for disqualifying Mr. Rutter's evidence was that he had a personal interest in the matter because in his book he says, this is personal for me. Now, in Kolani, Professor Nell testified about the deleterious effects of homophobic speech, and he testified extensively about his own ill treatment and discrimination meted out to him by virtue of his gay and sexual orientation status, and his evidence was accepted. In other words, the fact that he had a personal stake in it because he himself was gay and had been subject to discrimination on the basis that he was gay was not a reason to exclude it. Mr. Human's evidence was excluded on the basis that the physical and psychological effects that the farm attacks have on their victims constituted hearsay evidence. However, in the Kolani trial, the court admitted the evidence of Mrs. Mokoena of Power about a series of lesbian women that had been correctively raped. The court did not dismiss the evidence as hearsay, despite the victims not being called to corroborate their testimony. The court disregarded the appellant's expert evidence of Mr. Krauss about singing of the song Bizani Fire Brigade on the basis that he did not prove there was a causal link between the singing of the song and farms being settled out in the region. However, the Constitutional Court made it clear that considering the phrase to incite harm, it is imperative to point out at the outset there is no requirement of an established causal link between the expression and actual harm committed. The court disregarded the appellant's lay witnesses who testified about their personal attacks that they had suffered on the basis that they could not prove they were attacked because the singing of the song killed the Boer. However, in the Polani trial, evidence was admitted by MN, who testified about her personal abuse that she suffered because of her sexual orientation. The court says, like Mokoena, MN conceded readily that the incidents perpetrated on her cannot be directly linked to the applicant's offending statements. However, she added that the offending statements were exacerbating the current situation where people like her are being harassed. In other words, they provided important context. The Court of Quo relied on the respondent's expert evidence to determine the meaning of the song Kill the Boer. However, in Masuku, the Constitutional Court held that it has long been held that an expert may not usurp the interpretive functions of our courts, and that the experts in this matter could not be used to determine the meaning of the statements. The court relied on the evidence of Mr. Malema to determine the meaning of the song, despite Polani being prohibited from doing so. Now, these discrepancies create the impression that the different rules were being applied by the Court of Quo in a manner that is inconsistent with the rule of law. Litigants ought to be able to rely on the decisions of other courts when deciding how to conduct their own proceedings. In other words, the other cases must be guidance for litigants about how they will run their cases, what evidence will be used, what is important for determining context, what is important for determining the meaning of words. And if the rules are changed, then it changes the playing field. And there's a sense that some people are giving different sets of rules and different protections. Now, on the question of the listed grounds, Mr. Malema himself says, when I mention the word farmer, I see a white person. So when you say shoot to kill, kill the farmer, he's envisioning a person of a certain race being killed. Now, and I mentioned that the court in Masuku was able to see that the term Zionist clearly references Jews. In the matter of Hugo, Goldstone J. held that the prohibition on unfair discrimination in the interim constitution seeks not only to avoid discrimination against people who are members of disadvantaged groups, it seeks more than that. At the heart of the prohibition of unfair discrimination lies a recognition that the purpose of our new constitutional democratic order is the establishment of dignity and respect regardless of their membership in particular groups. The achievement of such a society in the context of our deeply inegalitarian past will not be easy, but that is the goal of the Constitution and should not be overlooked or forgotten. So the idea is that all citizens are provided protection by the law, that you cannot have Afrikaners being relegated to second-class citizens. You cannot have a double standard that is applied to them. There is a concern that the value of non-racialism is being undermined by a judgment like this. That if some races are given the impression that they will be silenced, while other races can say what they like about them, you destroy the very fabric of our modern democracy. The reason why South Africa has a promise of a future is the idea that it belongs to all who live in it, echoed by the words in the Freedom Charter. If some people are made to believe that they are second-class citizens, like they were during apartheid, that apartheid created different classes of citizens in a despicable way, that we will never go down that path again, it's important to embrace the idea of non-racialism. In Van Heerden, Moseneke held that the long-term goal of our society is a non-racial, non-sexist society in which each person shall be recognized and treated as a human being of equal worth and dignity. In Walker, Justice Sachs held that no members of a racial group should be made to feel that they do not deserve equal concern, respect, and consideration, and that the law is likely to be used against them more harshly than others belonging to other racial groups. And in Kamalo, specifically in the context of hate speech, Justice Sutherland says the following. He says, in South Africa, our policy choice is that utterances that have the effect of inciting people to cause harm is intolerable because of the social damage it wreaks and the effect it has on impeding a drive towards non-racialism. The idea that in a given society, members of a subaltern group who disparage members of the ascendant group should be treated differently from the circumstances where it's the other way around has no place in the application of the Equality Act and would indeed subvert its very purpose. Our nation-building project recognizes a multitude of justifiable grievances derived from past oppression and racial domination. The value choice in the Constitution is that we must overcome the fissures among us. That cannot happen in debate if, however robust among ourselves, one section of the population is licensed to be condemnatory because its members were the victims of oppression, and the other section understood to be collectively the former oppressors are disciplined to remain silent.
Is there any further submissions? You've been reading out your names, so we've read it already. So if there's nothing more.
Yes, there is one further statement to be made, which is that when looking at the clause designed by the court in Kolani, the phrase is as follows. It says, subject to the proviso in section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. Now, my learned friend Mr. Nkatobi described Lamont's approach in the original AfriForum case as being incorrect on the grounds that he said, well, there are two reasonable interpretations one could have about a song. And you could look at what the targeted group says and you could look at what others say. Now, and he says that's the wrong path to go and that it's not what the law requires. The fact that the new section 10 uses the word could reasonably implies that there could be multiple reasonable interpretations, and if any of them demonstrate the intention to incite hatred, then you are caught by the clause.
How does that relate to the premise of your address as an amicus, which is about equality before the law?
Well, the idea is that...
You argue in the case that you argued for the peasants.
Justice, the implication is that the law must be applied evenly. That it's important that we have a standard that is applied to everyone, which means that when we're interpreting the words in any future hate speech case, it's important that this court sets out what that test is, that everybody knows in advance. Is it a reasonable interpretation, or is there only one reasonable interpretation? That is important for the rule of law, that any litigant knows in advance what standard they'll be held accountable to.
I thought they know from Kolani.
Yes. So, in other words, Kolani tells them, yes.
Thank you.
I have no further submissions.
Thank you, Justice. Thank you.
Thank you, Justice Solduka. Justices, there are a very few points on which we think it would be helpful in a focused way as best we can to respond. And there are points we have had the benefit of hearing our learned friend's argument now, and I shall seek to identify what stands out as significant going to the core of the matter. I may say, so it is understood, our difficulty with the idea of, in some informal way, something being circulated without prior notice to the court or to ourselves is that we don't get to consider it before, we don't get to discuss it and have instructions, and the court is caught on the back foot too. We respectfully submit Rule 10 of this court is very clear in relation to filing of heads of argument. If you wanted to, needed to, as it sometimes happens in life, because life is full of surprises, to file a supplementary, you do, and you do it on a precognized basis. So for that reason, we as a matter of principle and also prejudice say that it's not appropriate for 16, as it is. I was wrong. It's 16 pages to be, as it were, distributed with footnotes and other aspects which we haven't had the opportunity. We've listened and followed now as we've gone, but we haven't had the opportunity to deal with it. But enough of crying. May I turn to squarely dealing with the points that matter. Our learned friend, Mr. Nkatobi, was kind enough to say that on appeal our argument was calibrated, and I'm indebted to him for saying that. It's a very polite way of saying that we have sought to confine, a very focused way of saying we're focused. And where we stand, as has emerged in debate with members of the court and is brought out very clearly by the contrast now between us and the argument to which we must reply, is this, that as Justice Matajani reminded us earlier, really the core is the fact that there is a quartet, or there's supported by the quartet of Constitutional Court judges, there is a requirement of objective determination. The question is then, was it the way it was applied in this case in compliance with that? And our calibration relates to the fact, as I said earlier, that Mr. Roots can read from his book as much as he likes and tell the court as much as he likes what he thinks. So, on the other hand, can Mr. Malema. But the question in the end comes down on the remodeled Constitutional Court, temporary, everything which goes to Parliament becomes permanent because it takes so long, the wording of Section 10. And it is indeed whether the words used could reasonably be interpreted. And that is absolutely the heart of it. A, objective, and could reasonably be interpreted. Now comes the core of it. And here Justice Molefe earlier, rightly with great respect, stressed, as we had sought to do, the issue of context. And it reminded me of the very epigrammatic first paragraph of a judgment in this court by Justice Nugent in, and you will forgive my Scandinavian because it doesn't exist, Aktiebolaget, Aktibolaget, and we only have the All South Africa reference, which is 2002-4. It is in the SALR, but 2002-4 SA All South African Reports 138, this court, paragraph 1. And it's exactly as Justice Molefe really was pointing at. The words are a quotation from Lord Steyn in RV Secretary of State. In law, context is everything. Now, where we part ways and where we respectfully submit the court will go with us or go against us is this. We say the context is not, as it were, retrospectively injecting into the arm of some poor listener, auditor sitting in Vredefort or Attridgeville or Worcester, the 1,700 pages of record. What it is the hearing of the words in their context. And what does this mean in these instances? It means that you have somebody, because we've got this video recording, we've got somebody sitting around South Africa, we've got people sitting around South Africa, a national audience, who are hearing these words being used there. What may emerge from the context? Well, that person will be appraised of a number of things. First of all, will be imputed, as we've been reminded by members of the court and others, with a knowledge, a working knowledge, let me call it that way, of South African history, of what I referred to earlier as the 3 centuries of wrong, of the attempt to make a transition to democracy, continuing economic injustice, all that. They will know that there is a strong political movement at the time we're talking about. It was within the governing party, but a strong group of thinking which is radical and wishes to say things which are shocking and to confront the stasis of the past. And here, may I say, I would entirely agree with my learned friend when he said that, of course, speech can be shocking, offensive, but perfectly lawful. It's what I meant earlier by talking even about words that hurt. It happens all the time. So, what it means is that the listener, the group of listeners, you can't be typecast, and here I agree too, as a supposed target group. It's wider than that. But it does mean that in a country like this, you have to go beyond, because of the fact we're not homogeneous, you've got to go beyond just the ordinary divides of age and gender and the like. And you're into the plurality of the population. And it is the problem Justice Keatley raised, and that is you're trying to arrive at a test objectivized in relation to, in my earlier example, treating a child or driving on the road or something. You do it in the circumstances, but with reference to something broader. What is it here that we have? Justice Keatley took us to the fact that in all the heat and dust of the Kill the Boer focus, what gets lost is Burn the Boer song and focus, about which, as I think she indicated, there is very little context. May I make a fundamental point? The fundamental point is that the context is not given ex post facto by people saying, well, actually, I thought I meant this, or this is the way I think I really, whatever, or I'm a writer of books, so I understand it this way. The court looks at it exactly. I think it was Justice Matajani who said that it's really the court who's deciding this, but in this normative, difficult way that has to be done. So the court looks at it, and the court says, let's start with the words. What do the words say? Are the words sort of a bit fudged? Do they admit of any confusion? No, they don't. They say, burn the Boer, and they say, kill the Boer. Now, on the face of it, could those words, not would they, but could they reasonably be understood by people listening to them in Vredefort or Umlazi or Musina, or wherever it is, Hoogste? Could they be understood as encouragement to people to hate or to inflict harm, the two surviving dimensions of Section 10.1, hate or harm? And I don't want to repeat what I've said earlier on harm. The cases are clear. It may well be that my client before was misguided enough, some might think, to advance a panoply of evidence, trying arduously to link what is a disturbing picture of people being killed in certain circumstances in rural areas to the singing of the songs on these occasions. In our calibration, we're not doing that. But it does not mean that the court has to follow the parties in misdirection by the fact that they try to prove something wider. They don't do it. But what happens is that the argument within the parameters is advanced to say, what Mr. Root says is not relevant, what Mr. Malema says is essentially not relevant. And we take it on that basis of saying, apply the could test, look at the words. The words are not vague, they're not fudged, they're not loaded with indirect meaning about cockroaches and the like, or even slightly, I don't know if it is particularly hidden in Masuku to talk about turning the children into fertilizer, but these are blunt and simple old verbs. Now,
Sorry, am I interrupting your flow?
I'm afraid, probably, but Justice Keatley, it's your job.
It's something I raised before, and please don't address me on it, fully on the race judicata again. But if your client's case were to survive as a new case, you might be arguing that that was on the basis, that was on Tuduhyani, that was on the basis of the new thrust of the, let's call it contextual link, let's not call it the causal link, the contextual link with farm killings, farm murders in South Africa. But it might be argued that once you eschew reliance on those 2 weeks of that sort of evidence, you left back, you might just simply be left back with exactly what Justice Lamont had before him. We're down to the words again.
Sorry, we're down to the words.
We left with what was before Judge Lamont.
Yes.
And that,
no.
I certainly have difficulty. I understand, well, I'm assuming you might say there were new instances of. Let's accept that that's a fact. But but legally, one is left with the same question. Is the singing of the song hate speech?
Yes. May I try to compartmentalize the res judicata aspect, because as much as you don't know, as much as you don't want to hear me, I do need to just respond, if I might, on an aspect. But on the major point of where we are now in our approach is objective test could reasonably in this pluralistic society. And you can't narrow it, you can't have say, well, off the street white person would not have heard of a struggle song. You've got to take it that the person is reasonably informed, and so allow for the fact that they will know there's political history behind this. They won't know the detail. You can't impute them too much, because I keep saying I'm not Professor Gunnar. And this is the test you would apply in defamation. It's the test that you would apply in crimen injuria, something like that. It is context, but it's start with the words, and then comes my answer really to Justice Keatley. We do know, and we do have context. And the context is recorded. And let us allow into that context an aspect emphasized by our learned friend, that is cynical. There had been angry white people who had broken the law. Let's take that, for example. I'm not quite so sure that this is any part of what we see or listen to, but let's accept that. Where does it take you? I say to two things. One is that the speaker has a primary responsibility to control and set the context, which is to say that we are singing this because, and it was part of the debate earlier about if the ex-president could sing Mshimiwami under circumstances explaining that, or this is the funeral, or this is the wangi, whatever. But what I'm saying you can't say in that which is actually addressed to the country is verb, object, and motion of shooting. And you can't credibly then say, going right to the fundamental test, that it could not reasonably be thought by some people that because precisely we are provoked, and provoked possibly by some white thugs or misbehaving white people, this is the language you use. The answer is still that it's hate speech. It's not taken away. And there was no giving of that kind of controlling context. There was not in what you see or hear, and was not conveyed in any way. Why? Because, and we know why, because of the double entendre at least, which is intended by the speaker. But I keep forswearing the intention of the speaker, because in this case we would ask you to note, and members of the court did not put any difficulty in this regard to our learned friend, that Mr. Malema has made crystal clear what he means when he uses the language. I say it's not on his tongue that it matters. It matters whether it could reasonably be heard in the ears of some people, whether on farms or old age homes or in luxury flats.
Any further submissions on the reply?
Oh yes, I won't be long in relation to what I've heard. So we say that really lies at the heart of the matter. To summarize what we're saying, yes, we are back to the question of the correct application and whether it was done objectively. We say it wasn't, and it did no help to try and prop up the judge, Arquo, with respect as our learned friend did, by saying, well, there's all this evidence and it failed. It didn't show that somebody was really grieving for long afterwards, and it didn't show the harm. All that was, I'm about to say misdirection, but misdirected in fact. The parties pursued each other into the mealie field. And with great respect, The true issue for the judge is to say, no, wait a moment. I'm sitting here, just as Justice Matajani said, it's for the judge to decide. I've got to do it in context, but I must be very careful that I'm not going to sit back and be, as judges always say, whether it's a motor collision or something else, you don't retro-reason. You don't impute things into the pot which aren't there. You take the person that night watching what was said, listening to what was said. And you say, and the test has been used, and there's a case called Wiley in this court, Wiley versus Natal newspapers. A judgment of, I think it was Justice Demont, said in defamation, you take the person who's listening as a person in the evening with a beer in his or her hand who's listening or watching to what happened. They're not professorial. It's what are they absorbing from this? Could they? And here it's, could they, listening to this reasonably, see it that way? So those are our submissions, and we are indebted to the court for following us in or out of the mealie field.
If we are in your favor, what are you asking for? I see from
Yes, I should clarify that. Thank you. What we're asking for, let me be very clear on that if I can. If I can find the draft order. We were agreeing in the debate which took place with members of the court that the declarator that we were seeking is too wide, can't operate inexorably in rem. So it would be in one, the words and translations, etc., of the words, phrases, and songs on the occasions set out in the complaint. Or one can then just repeat what they are, but on the complaint constitute hate speech. And then two, the respondents, this is now beyond the declarator, are interdicted and restrained from the public use, singing, or chanting of the words or songs set out in paragraph 1. And may I then, just in that regard, deal with a residual concern which we've had and no doubt members of the court have. What if the respondents do, on a future occasion, although I thought they were all too young for this, but that there is a funeral of a colleague who has been a former combatant or whatever. You would be then in the position that there would be an order which says that they are restrained and interdicted from the public use, etc., etc. You'd be left with the same problem this court faced in the flag case, where it tried to deal with people running around with the flag in the future by saying gratuitously using the flag, which I think was maybe intended that if there was some former veteran of the border war who they wanted to bury under the South African flag, that wouldn't be gratuitous. But that's what this court ordered, and we would refer you to your order then in the flag case. I myself submit, it'd be better to say from the public use, etc. And if anyone were to come and say, but now what that order does is to hit this or the other, and that can't be intended, etc., the answer will be what this court has held in cases going back to Genti Ruko versus Firestone, that you interpret an order in relation to the judgment, and it would indicate that and confirm and state clearly that what you are not doing is stopping a situation where you're not interdicting them from a specially justified public use. First of all, Section 12 provides for the statutory exceptions, but if one goes beyond that and say, well, yes, there may even be other ones because funerals aren't in there, then you would say that order can't and doesn't apply to me. And you would do the same if you granted an interdict in a case involving farmers along the Orange River relating to a particular problem, and later it was said that order cannot possibly apply in instances of rinderpest or flood. The answer would be yes, read our judgment, it doesn't. Thank you. And may I say that there was a moment of ambition to ask for costs of 3 counts, so we would ask for costs of 2. Thank you.
the written heads of arguments and the oral argument that you put before us, Mr. Nkudobi. I know you tried to put in your written heads, but I think you did quite a good job.
My clients often believe the contrary.
I was about to say, Justice Soduka, I was hoping that you wouldn't think it's good.
In the circumstances, we tried to put in these written heads. So I just want to say that he did well. Thank you also to the Junior Counsel who have assisted in this court in the best traditions of the bar. And thank you also to the amicus. We will take some time, and the debate has been very useful, and judgment is reserved.